to 20,
Yes.
21 to 34, 35 to 39,
Item 38, Lordship, praying for an adjournment because, my lords, the requisites were filed late and yet there is a noting that has not been served. So let it come.
You filed the requisite late.
Lordship, Lordship.
So your pays little cost.
That is why I'm in the beginning, I am, my lords, mentioning.
Okay, it's fine. Little cost for the business a bit that you filed the requisite and wait. So the same requisite may be utilized for the purpose of serving.
Lordship, Hon'Ble.
Yes.
Item 40, 41 to 46, 47 to 53,
Item 52.
50?
Last year, you have also the consent of minority senior. I have also taken consent of him. And today, it has been urgent to some other date. Inadvertently, it has been listed. It is a CRL beta test.
It was already urgent. No, it was already urgent. Why?
So, Friday.
Okay, 1 minute.
Actually,
I'll just check it out.
तीन
Okay. Just check it up. Huh? Okay. Yes.
I want to mention my petition.
Let you.
54 to 61, 62 to 72,
My lord, item 66. I am for the opposite party number 2. My lord, I am praying for 2 weeks time to file a
Let us
counter
see.
affidavit, my lord.
Let us see the other. Let the other side.
My lord, my senior.
Okay. Let counsel for the opposite party number 2 seeks an adjournment for filing a response to the petition. That you will do so within a week, please. There. Yes.
entry model.
Is there any entry model? Okay. Entry model.
Obliging.
73 to 80, 81 to 88,
Yes, I have just. I've done it.
My lord, item number.
That matter has to be detached.
CRL.
Yes, I know. I'll verify. I'll do it. Yes.
My lord, item number 87. I am appearing for the appellant. My humble submission can be taken up any day in the supplemental list so that it can be taken up.
87.
87.
These are
Hearing matter.
Hearing will see. Hearing. Let us miscellaneous matter. Let us. Yes. Yes. Any mention?
My lord, item 93.
One after another.
1 minute. Item 93 minute.
90.
Though it's listed for hearing, but it's virtually for bail. I am in 4 years inside the custody.
I'll take it up today. Okay.
My lord,
93.
93.
I'll take it up.
My lord, 94, my lord. It's a appeal, my lord. 75 years old man not supplied the document. Kindly for which time may be
Which
granted.
one?
94, my lord.
Who are you?
I am the appellant, my lord.
Okay.
For which time, my lord.
Hold on. Yes. Give the memo.
My lord, CLMC 1976 of 24. The matter was in the list in the 2nd week of December. Wherever the delisted has not reached. So the petitioner is an
Give
advocate.
the memos.
The lordship already had this matter.
Yes, we'll see.
It's a review, my lord. It's a
Please.
review.
Review.
My lord.
What is the urgency review?
The urgency is a matter of 2012. Despite repeated approach.
2012.
Well, initially it was
No urgency.
why it has not been listed. There is some problem because at the time of the main order was passed, the service wage was division bench. Now it is single bench. That's why there is the confusion where it will be listed. On that ground, it is not.
I was just wondering whether you are instrumental in not getting it listed or
No.
Yes.
Yeah, I have tried
Just
my
take it
level.
up. Take it up and
Madam.
yes. Yes. Let us start. No mention. Yes.
item 1,
Yes. Yes, sir.
My lord, on the last occasion, my lordship was pleased to instruct that this copy of the final form, that is charge sheet, I have already served on the learned friend, my lord. And in this case, I have challenged the order of framing charge dated 20th May 2024.
Yes.
Specifically, if even if I have filed for husband and wife, but I am giving weightage to the prayer of the petition number 1, that is the wife, who is a government servant. And the last occasion, my lordship is that if there is some disproportionate asset in my name, then independent proceedings should be initiated against me, not in the aid of 109. Because I am not a merely housewife. I am a government servant. I am filing the service that is income tax return. And my income has not taken into consideration added 109 as abatement. That was my lordship was pleased. Yes, it is a good one, but instructed the state council to take instruction.
Yes,
Frankly speaking, I don't recall what transpired last time, but in the order, nothing is written. But under the aid of 109, why can't you be prosecuted?
No, once I am the government servant,
Maybe
but 109 cannot be
government
applied.
servant and your wife also.
Wife,
Oh, you can very well.
there is no,
Very well, you know.
my income is, my lord, my income is more than that the
Show me
disbursement.
that. Show me that part.
That, but that is why my lordship directed to file.
He has to give the calculation.
Calculation is- My lord, in
Hey, he says the charge has already been framed.
Or it did not matter.
Then charge has been, you file a review petition challenging that charge order. Where is the charge order? Let us see.
charge already my running page 21.
One.
21, running page 21.
Then you have to file a revision petition. You are challenging that charge.
My lord, my lord. Only one sentence that there is sufficient materials, nothing more.
No, this is the only charge that the cognizance has been taken. Where is the charge?
But there is
Please come to page
sufficient
22.
materials against us, hence.
Please come to page 22.
My
Why
lord,
are
my
you
lord.
confused? 20th May 2024, the cognizance is taken against
Taken,
you.
but the, my lord, held next line, issue summons to the.
That's right,
My
cognizance
lord.
is taken, summons are
Sorry,
issued.
sorry, my lord, sorry.
You completely missed the point.
My lord.
Okay. So, but then in that case,
For
you
a
know,
judgment.
for it to maintain. How do you justify why cognizance order will be passed? Just state.
Because two things, my lord.
Hmm.
My service period.
Well,
that
you
is
have,
not-
sir, the problem is everything you are saying orally, nothing is placed on record.
No, those documents have been already filed, my lord, by this.
I don't know because you have to satisfy me.
Then, my lord.
You have to satisfy me. What have you filed? Nothing. You filed the impugn order, you don't know even it is
My
charged or
lord,
cognizance. This
as
is
per
the
my
case.
lordship direction, I submitted the final form. That is the charge sheet. On the
Just
documents.
check it up. I can't help it because see, the only impugn order is filed. In fact, cognizance is taken. You have to make out a case.
My lord,
here.
then
Right here.
only 1 week time may be allowed. I'll file.
Right on. Learned counsel for
The calculation
petitioner,
sheet I'll file.
seeks to file additional documents to substantiate it. Be the matter of. Yes.
Next week, my lord.
We'll see. Oh,
My lord.
You missed the point. Real point you have missed.
My lord.
You should have given your calculation, income tax, whatever document you relying upon. Nothing, you have not filed anything. Anyway, we'll see. Yes. Yes.
Attempt to prefer a passover.
Passover, okay. Yes.
May I please, your lordship? I am for the petitioner.
Yes.
Uh, I seek 2 weeks adjournment that I will go to file a IA in this case. The petitioner challenged the order of taking cognizance. This is a case of on the offense under section 138 of the NI Act, and there is delay of 1 year 5 days for filing of complaint petition without sending the delay condonation petition to this accused petitioner. The court has taken cognizance of the offense.
Yes. Where is that? You see, there is an application. You just see the application 142. What is this application?
My lord.
Where is the order by which the delay is condoned?
On 27th 1/2023.
Yes. Yes.
I will file a IA in this case. So 2 weeks adjournment. I want 2 week adjournment.
You are asking for adjournment. Why adjournment?
I will go to file a IA to stay the proceeding of the land trial court.
As you satisfy me, you have a case or not, then the stay You will ask the stay later
My
on.
lord, my lord,
If you satisfy me on the oral prayer also, I can stay. Show me.
my lord.
Why the court can't condone the delay? Just tell me.
Who condone the document is found that there is sufficient cause for the party has taken file petition with the limitation period as prescribed by no reason assigned by the land and lawyer court without assigning any reason for delay.
No, show me condonation of delay application. Where is that condonation of delay application?
My lord, annexure.
Yes.
Annexure 2, my lord.
2. Yes.
Roll page 15.
Yes.
This is the petition. I have received the
2023, passed by the sub-collector Sadar Kata, mutation appeal number 267 of 2021, before the Honorable High Court of Orissa and WPC number
Status quo order was passed.
status quo order. Let's see, kindly see, they mention, my lord, the mutation appeal number 267 of 2021. Let's see for a moment, my lord, they pay $69.
60?
$69.
Okay. Yes, 69.
The lordship, my last portion, last paragraph, my lord.
Mhm.
That was reflect, my lord, the khata number 277, plot number 734.
734.
734. Now, my lord, what property we have sold, my lords? Let's see, kindly for a moment, the page 94. Page 94, your lords.
90?
94, my lords.
Yes.
94. That's you got it. Schedule of the property.
Yes.
That, my lord, the khata number 676, plot number 733, not, my lord, 734. I've never been sold on that property. my lords.
What the writ petition pertaining to what?
Read petition, my lord. This status quo, that, my lord, the lordship, may kindly for a moment, another thing, my lord, lordship, I lord. Lordship, they said, my lord, I have sold the property 17/1/2023. But prior to, my lord, I have sold the property on 4th May 2023. That is on page 87. That interim order was passed by this honorable court on 9/5/2023. Prior to the
All these things
Yes.
are
lordship, may prior to that.
to be
And
threshed out. How can I?
and then lordship may similar nature. No.
What similar nature?
No, lordship may
Facts are-
see that your investigation is on, my lords. I'll furnish all the documents. Yes, sir. Lordship, that lordship, lordship has passed the order.
You give all this paper to the police?
Yes, sir, that is a lordship.
Yes, I'll pass that on.
That's your lordship.
Yes, you give it to the police.
That's your lordship.
Let the police.
Because absolutely, Miller, that is the said plot I've never been sold, my lords. No.
The petitioner is allegedly one of the accused in the FIR number so. Allegation is the petitioner. Then counsel for the petition submits that he is land subject which is alleged to have been sold is a different land from that of the land which is subject matter of judicial proceedings, subject matter of judicial proceedings. He has relied upon various documents in his present petition to intercept this court that no case is made out of it. However, the fact remains that the investigation of the case is still going. Therefore, the real course would be for the petitioner is to produce all the documents before the investigation officer, who shall deal with the document, deal with the document, and while filing the final report of the closure report under section 173 CRPC, shall deal with the document in accordance with the law. And for with this observation, it is not disposal. Great, sir.
Item 7,
May I kindly pass over the matter?
Yes.
item 8,
May I please? My lord, in this application, the petitioners have challenged the order dated 30th/7/2024, my lord, where the Lawrence Court below has rejected an application on section 205 CRPC, my lord, arising out of a complaint case, and cognizance has been taken on section 420, 341, 294 by 34 IPC, my lord. Yes. And that apart, my lord, petition number 1 is working under judiciary.
She was posted, she is posted at Berhampur Jersey, under Berhampur Jersey. Whereas petition number 2, he is her brother who is working at Chennai. Under such circumstances, my lord, I.
No, but have you once also appeared or not?
No, I have never appeared.
Once you appeared, get the bail, thereafter remove application. That observation I'll give. The case should start,
My lord.
the process should start.
That is why, my lord, I have filed an application on section
Oh,
405 to
see,
dispatch a private complaint, my lord.
Maybe private complaint, but you have to surrender to the jurisdiction of that court and the proceed should, the complaint proceeding should go on. And but
Because
wherever there is a difficulty, you move application, I'll give that
My lord,
observation.
problem.
As and
My
when
lord,
required,
here
you have to go.
the case is pending here at Kotak.
That's right, once also, but there is a complaint against you.
Yes, that complaint case was filed before the SDGM Balangir and by virtue of an order passed by this honorable.
I don't know what is the complaint, I don't.
My
know.
lord.
Very serious.
What are the allegations, huh?
Serious allegation.
Allegations?
Serious. What at all, my lord, allegation is that I demanded 5 lakhs rupees as a security for the marriage
And she has
with the
paid-
complainant. This is the seriousness of, as my lord and friend has
He is
stated.
he is the my lord, a court staff.
so-
Everything has been dealt by the lord and magistrate while passing the order.
As and when required, you appear and your application will be considered at first.
All right, my lord, with that observation, because the
Right.
case is posted
Petition
to Wednesday, so at
Petition
least,
is agreed by, where is that order, sir?
my lord, order at annexure 4, my lord,
Page 20, my lord.
page 20.
Petitioner is agreed by the order dated
27.
30th July.
My lord,
Isn't it?
My
30th
lord.
July 2024, whereby their application, petitioners, their application under section 205 CRPT have been done by a region order, by a region order. The trial court trial court rejected the application inter alia stating ఏదంటారా ఈ cognizance para treatment cognizance of the council petitioner submits that the petitioner number 1 is a employee
my lord,
and the court employee who is posted in Berhampur, whereas the petitioner number 2 is
is a working in a private company and posted at
working in a
Chennai.
private company and posted in Chennai. The proceeding is going on before which court? Balangir. SDGM.
SDGM Kadarkata.
Therefore, physical presence of the petitioners is not possible on every date appearing, and hence they will be application, and hence they move application. The submission made by the petitioner may have many benefits, but fact is that the petitioners appear before the court and agents and required, and whenever there is a difficulty in appearing physically, they can use the advertisement application under 205 CRPC or 317 CRPC. That's your therefore, I find no reason to interfere in this matter. However, liberty granted to the petitioner to make the first application for the court below for agency as and when it is necessitated as a necessity to such application to be changed to press on its own with this application.
After appearance, my lord, after first appearance.
My lord,
Indicated.
my lord, may I pray one thing because the case is posted to Wednesday. So may I pray that some day may kindly be given so that I will surrender and go on bail.
Counsel for the petitioner at this stage subject instruction that his client would be appearing.
First week of March.
Appearing before appearing or surrender before the court on or before 5th of March. On or before 5th of March, and resort to for the remedy available to and on the subsequent date, if necessary, the application under section 205 would be.
Till then, no question.
Shall be moved. Till then, no question.
205
Oh,
317 your lordship.
317.
My lord, already.
Minor.
You appear, get the bail, and
Minor.
thereafter you move application out.
By
Yes.
5th March, they will surrender and go on bail. Thereafter, 6th.
Thereafter you, if required, move.
Minor. Minor, till then, no courtship.
Yeah, I have said.
Obligement.
Yes.
Yes, madam.
Yes.
My lord, this is against DV case, my lord. The fact is that in the year of 2019, my wife left me with one contractor. They both resided in the Baleswar. There was a
Your wife left, fled away.
yes, claim. In the year of 2019, after 5 years, she filed a DV case that against me and added my
Maybe she wants to revive the relationship.
no, my lord. That case is pending before my lord in the PRP 112 of 2024. As per my lord's
Where
direction.
from I'll get that she has left, you
Yes,
have
my lord,
to
it is his her petition.
show me. He has left your company
Yes,
in 2019. Show me.
page 19.
The problem is you people don't file the documents. That's the
It is that petition. my lord.
everything. Yes.
It is his her petition.
Where is your reply?
Yes, I have replied. I have
Where is that?
Page 27.
response. I have filed that.
Where does she say that I have left the company?
My lord?
Where does she say that she has left your company
No,
in the year 2019?
she is saying that I have left that in the year of 2019. But
Where is that?
my lord, it is page 25.
Show me exactly.
My lord, my lord.
Exactly that line.
Yes.
But he has, this petitioner has written in page 30, para 7. That the fact of the case is that petitioner one voluntarily rejected the copy of the response. But in there, her petition I have not.
My lord, page 25 रे से लिखी थी प्रकाश था कि 5/9/2000
I read it. ये आरंभ 1 नवंबर रे विताड़ित କରାଯାଉଛି. Not she has not left. You have thrown out.
My lord,
Yes.
how can I
Your reply to that paragraph. Show me.
Yes.
Yes,
Your reply to that. Very good.
30/7.
Huh?
Page 30 paragraph 7. That is the proof fact of this case. The petitioner one
voluntarily
voluntarily.
rejected the
Okay,
company?
I'll issue notice. He is, in any case, he is not in company.
My lord.
Whether he has thrown him out or she has gone. Fact remains that from
Unless he comes
31st August 2019, she is not
Unless he
staying.
comes,
Learned counsel for the petitioner is seeking what are you seeking? Quashing may not be possible, but let us see.
Yes. Settlement happened.
Seeking quashing of the DV case, DV case number 32 of 2024, pending in the court of DGM Baleshwar against him, initiated by the opposite party. By taking me to the copy of the contents of the complaint, the Learned counsel for the petitioner submits that from 31/8/2020, petitioner has the opposite party has left the company of the petitioner. I have perused the contents of the complaint and the reply filed there too. It is apparent from the pleading that indeed the petitioner and the opposite party are staying separately from 31/8/2019. Issue notice to opposite party written evidence also. And in the meantime, petitioner may move application for seeking adjournment before the court below, owing to the fact that the matter is subject before the court. Yes, next. Yes, sir. Yes.
Challenging the order of cognizance,
Yes.
challenging the intercriminal proceeding. What
Are you challenging the cognizance?
No,
of-
no, intercriminal.
Enter. Yes.
Your lordship, annexed.
What is the state that it has been filed?
Under section 498, 323, 294, 506, 34, and 4 of the DPA.
Hmm.
The petitioner of the mother-in-law and father-in-law.
I'll issue notice. Matrimonial dispute.
Yes.
Matrimonial dispute. Let us.
Specific allegation against him.
Specific, not
Oh,
specific.
that these allegations, you know. Matrimonial dispute. Wife makes allegation against the entire family. and relatives, whoever it is there. Issue notice. I'll send it to mediation if possible. Issue notice to opposite party, written also. This being a matrimonial dispute, I feel it appropriate to send the matter to mediation, High Court Mediation Center कर दो, and liberty granted to the petition parties to even appear before the mediation center to video conferencing mode. Where are you? Chhatrapur. If necessary. If necessary. In the meantime, proceeding before so and so state, awaiting the mediation report. I stayed the proceeding. Participate in the mediation. If something comes out, it's all right.
Mediation, my lord.
High Court Mediation Center, I have said that if possible, if necessary, appear through video
Please,
conferencing.
please.
Okay. Okay.
Item 11.
Yes.
For
Yes, madam.
watching of the proceeding on the ground that the FIR was lost in 2010. And till that, the investigation is pending so far as petitioner is concerned.
My lord, you should have
Maybe 2010, we are 25, 15 years.
in jail custody, my lord.
Yes,
Sir,
That's what he says. Where is the charge sheet? Why have
actually,
you not filed the charge sheet?
why next date? ma'am?
Don't file
Today is the
them.
first date.
Don't file, leave them
Yes.
15 years.
my lord, actually
What
what is,
kind of investigation you are carrying out? 15 years. What are the allegations?
my lord, allegation that he is the Maoist.
Unlawful activity.
Unlawful activities. My lord, what has happened?
Is referred to tribunal? It's not
No,
referred.
no. The 4 persons who were apprehended at the spot, they have already been acquitted. And on the basis of their statement, I have been tagged to this case.
But you must be absconding. That's the
No,
reason.
yes, my lord, but because at that point of time, I was not-
Then why are you saying that charge
I
sheet has been not filed?
my lord,
Charge sheet has already been filed. Who are the people, those who have been apprehended?
no, my
And
lord.
they're put to trial, they are acquitted.
I know.
And if you are absconding, what to do?
My lord, what your lordship may kindly bear with me. 2014, I was arrested. And since 2014, I am in custody.
In other case.
In so
Not in
many
this
other cases, maybe,
No.
but I am in custody since 2014.
So
And-
delay can't be attributable to you. That's
Yes,
what you.
yes.
I issue notice, let us see.
Yes.
Huh? Take it up. Take it up. Who are you, by the way?
My lord,
Who are you?
I am
The
the
leader.
Oh.
Maoist.
Oh, this Sabyasachi
Sabyasachi
Panta.
Panta.
He has many cases.
My lord, several cases are pending in different districts. In many of the cases, he has already been acquitted. And some are still pending. And most of the cases, 10 years, 15 years, like.
He is the Maoist leader.
My leader.
He's one of the
Yes,
top-
one of the
top-notch
topmost leader.
simply issue notice, let us see.
Oh, bless.
Yes.
Item 12.
Yes. Yes, sir. What is that? Pass over.
Item 13.
My lord, the petitioner challenging the order dated 18/1/2024 passed by the London Magistrate on an application under section 125 CRPC directed to pay 3,000, 2,000 respectively to the opposite party number 1 and 2, your lordship.
2000. What is it?
Now the outstanding amount is 4,30,000 and warrant has been issued, your lordship.
You are challenging what?
Maintenance and as well as warrant order, your lordship. Warrant order, I have,
Warrant, I'll say go and appear and pay.
my lord.
I'll say it. I'll say it subject to you appearing and paying.
Yes,
Maintenance amount you have to pay. Sir.
Yes,
All survival of.
yes, lordship.
These maintenance are because of the to avoid vagrancy. That's all.
My lord,
Not beyond that.
I will pay, your lordship.
So then, what do you? Where is the
Imping order is.
order issuing?
The operative person is page 22, your lordship.
Huh?
Operating person is page 22, your lordship.
22. Okay.
Opposite.
Petition is agreed by the order dated 18/1/2024 passed by the SDJN, Padampur, in criminal miscase number 32 of 27, whereby the petitioner has been directed to make good the maintenance amount and maintenance amount awarded and the areas accumulated there. The areas comes to be areas.
4,30,000, page 9 of the IA, your lordship.
Terminating of record that the area is around 4 lakh.
4,30,000. I will, at a time cannot pay, your lordship.
4 lakh 30,000. Then counsel for the petitioner submits that owing to the financial health of the petitioner, he is not in a position to make good the entire amount to the opposite party in one go. However, he is inclined to make good the payment on installment basis. He seeks indulgence for this court at this stage as the NVW has been issued against him by the order dated
10/9/2024.
10/9/2024. I am not inclined to entertain this petition at this stage by altering either the maintenance or giving indulgence for non-payment of the maintenance amount. However, regarding the submission made by the petitioner, the NBW order issued against him in the state till 5th of March.
My lord, I will pay something at a time.
5th of March 2025, subject to petitioner paying 50% of it. Yeah? 50% of it.
25%. 25%.
Why are you they have to survive also.
Not in a position. 1 lakh.
Paying 1 lakh rupees.
My
1 lakh
lord.
rupees of the first installment towards the continuous amount. With the petitioner is given liberty to appear before the court and to sort of all other remedies under.
My lord, warrant has been issued in the execution case number 61 of 2020.
It is right.
My lord,
Issued by
same.
NW issued by which court? AGM. Also in execution.
In execution case number 61 of 2024.
It date till 5th of March, subject to making payment of 1 lakh.
Yes.
Okay. It made clear that this court will not express any opinion on the names of the case. Yes. Yes.
Item 14.
My lord, in this case, my lord, I have challenged the quashing of the FIR in the ground that the caste certification file has been instituted by the BO. On the allegation that I procured caste certificate in 1997-98 and procured the BD qualification. Your lordship knows a rule act is there governing this issue. Who can inquire about it, declare it is a fact, and direct the authority to take action. Then only the will be done. Your lordship knows the act has come into being.
But sir, this is the only the FIR is registered.
He is declared in my caste certificate fact. He is not the authority.
Who is declared?
Your lordship see.
Where
He can declare.
Where is that, sir?
Page 15, lordship see.
1.5.
Paragraph 1.4 is his FIR. Page 1.5, your lordship see. It is certain that
Block development education.
you
have other remedy. You have to challenge this order itself. In the writ petition saying that he has no authority to declare it.
You say FIR is implied. I have been
FIR
prosecuted.
is a different course altogether. Investigation is going on.
Yes, madam.
FIR is laws on the basis of this declaration.
You know, see,
The declaration has to be challenged in a different proceeding.
you know, see, just one thing. You know, see, page 4.
And neither the criminal court can decide it, nor the IO
You know,
can decide
see,
it. Why are you wasting your time? Go
Yeah.
and file a right petition.
Just one line, your lordship.
Yes.
Page 4. Your lordship, I have quoted the section 6.
I understand it.
Yes.
I understand you have a fantastic case,
Yes, madam.
but not in this proceeding. I understand.
This is on the basis of the report of the assistant registrar.
He says that this block development officer has no authority to declare the caste certificate to be valid.
Yes,
And he has declared on that basis you have registered an FIR.
Yes,
And he has to challenge that
yes,
there somewhere else.
yes,
Not in the act.
your lordship knows state level scrutiny committee is framed under the act.
I understand it.
Yes,
Why don't you
after
go-
the judgment of the apex court,
So,
and there are special persons has been
I understand
appointed.
it. Why can't you go and challenge it?
Yes, sir. Just one thing also, earlier cases also, your lordship knows, the scrutiny committee report is the FIR. In many cases, I have, your lordship, I have apprised your lordship.
Challenge that order.
Yes, my lord.
We cannot challenge that.
The committee report can be the FIR. You can, a BO, any authority cannot institute.
Then wait, then let the investigation, go and tell the IO all these things.
Yes, right.
Go and
Well,
tell the
you
IO.
know, let's see.
But why don't you challenge it? This,
I will challenge it. Well, let me first
better you
apply.
challenge that,
Yes,
so that.
Your sir, statute is there, rule is there. How can you, against the law, how can the FIR can be instituted?
Block development, block education officer.
Yes,
Block education officer, why it's office order dated 27/11/2024 has declared, what is the caste to declare?
yes, ST malad. Only ST says.
Caste certificate for the
Nothing. No inquiry.
petitioner. ST.
ST.
Caste certificate of the petitioner should be invalidated under law.
You see, page 15 he has declared it.
By violating the the procedure prescribed under law. On the basis of the said letter dated 27/11/2024, now the FIR has been registered with the petition. Therefore, he seeks to challenge the entire criminal prosecution initiated against him on the basis of the certification given by the block education officer, block education officer. Investigation in the present case is still going on. Therefore, I am not inclined to entertain this petition. However, petitioner is granted liberty to place the entire effect of the investigating officer who shall deal with the same in accordance with the law while submitting his report of the final form under section 173. With this observation, the petition is disposed of. You now if I challenge that.
Yes, your lordship, page 15, your lordship, see, page 15.
I have seen.
15 of May.
I have seen it.
Yes, sir. It is asset under the Kamandaka had produced to first censored.
I have seen it.
Your lordship, he cannot declare it.
Yeah.
Neither
You
can
must
declare.
challenge.
One thing also the act says, no court said take a cogniance.
Not applicable to this case.
No
It's
court.
97, 98.
But he is entitled to challenge that.
Yes, yes.
He should challenge it.
97, 98 ele bhi proceeding habo, STC, act rahi habo. Your lordship, a provision
Find
is
a
there.
petition.
Earlier, if any case certificate is issued by any authority, then it of course can be questioned by this act under the act.
Yes, thank you. Yes. Next.
50.
Yes.
That affidavit we are supposed to be filing, my lord. Unfortunately, the delay, we were filing it before, my lord.
What is that?
That matter, my lord, where summons were issued.
Your lordships had indicated that the matter will be disposed of today. That matter, your lordships.
Now let me understand what is the case.
My lord, the case is, my lord, may kindly take, my lord, the FIR.
Have, Mr. Naik, have you got the additional affidavit which they are filing now?
No, your lordship, not.
I have solved it. I'll solve it on your associate counsel is here.
Yes, sir.
Mr.
Yes, yes,
Naik
he's
has-
always. Yes, he's there.
I'll
He's
solve
there.
it.
Then he obviously has
Yes,
to read
yes.
it, right? Mr. Das and Mr. Das and Mr. Thurler's senior counsels appealing for the petitioners through their billing counsels have placed on record the additional affidavit, copy of which has been supplied to the counsel, Mr. Naik. Mr. Naik to reflect upon the additional affidavit, address this court and make that a hearing. This is the matter next week.
Let's say after 2 weeks, your lordships. Next week, I have some problem.
Not after 2 weeks, rather we are discussing sometimes
6th of
March.
Yes, your lordships. Yes.
March, you say?
No, 6th of February.
February, 6th February, this.
Subject if Mr. Naik is not intervening.
6th February?
Your lordship, today they can argue the matter. I'm ready for affidavit. There must be nothing in the affidavit. So let them argue.
Very interesting. Today you have received, you are not ready it also. Your junior got it, now you know what is.
Not.
What is written?
Yes, your lordship. 6th.
Without looking at there is nothing in the affidavit.
Yes,
Very
your lordship.
Mr. Naik is always.
Might be there is some
Yes, yes.
privileged communication between your client and him, his client. Your client and his client.
No, my lord, that can be made between me and him, my lord. He's the nephew of mine, so probably I have.
Maybe this is a privileged communication. I can't comment that.
Your lord, 6th.
Something, that's what.
6th March, your lord, 6th February, your lordships, I'm ready. 6th.
6th February.
Yes.
Great. Item 16.
This application. I'm sorry, my lord, I forgot to mention, probably, my lord, is little time today in the afternoon, if it is. My lord, that item 92 has been heard in part by my lord, that regarding that superintendent of police, vigilance matter.
Let us see how the bench proceeds.
Yes, no, otherwise, my lord, can just get me any date, my lord, at 3 o'clock, I'll go.
Yes, I'll just check it up and tell.
Yes, sir. Any date after 12th, my lord, after 19th, it can be fixed also, my lord, if it.
19, item 92.
19 at 3 o'clock.
19th.
19th, 3 o'clock.
19th for 20, 21st, something. 19th will do.
19th at 3 o'clock, my lord, will be deeply obliged.
Okay.
If my lord, I'll request that that 3 o'clock thing may be fixed, my lord.
Yes.
I'll finish with it. And then
19th could go. Okay.
Item 16.
16, my lord.
Yes.
Offense under section 379-34 of the IPC. I filed this application for quashing of the criminal proceeding on the ground that some of the co-accused persons, they were arrested. And on the only basis of my implication is their confession of the co-accused, except that no material is there. Not only in the present case, but also other cases he has been implicated, the present petitioner. I had approached this honorable court in different other cases are concerned. This honorable court, without matter quashing the criminal proceeding, directed to be released on bail.
Must be in bail petition.
No, man, in CLMs. Giving.
Investigation is going on.
For the two cases.
Page 22.
I have passed this out.
No.
I know, I don't pass this time. 14 might have passed. Okay.
My
482 proceeding. You have to go to bail. These are not bail court.
No, that I am submitting. So far the merit is concerned, except the confession of the co-accused, not a single material is there to implicate the petitioner in the Addis Commission.
Okay, what was the context filed, the petitions filed there? In this
there is the context is same.
Let us see the order.
Same along with additional ground was taken that the co-accused persons who have been the confessed.
How are you covered by this judgment? Let us see. What are you saying?
That I am not saying. In those cases, the co-accused who confessed before the police, they have been also acquitted by the law and trial court. Additional that ground was taken in that case.
Then that is the main ground.
No,
the co-accused on the whose confession you have been made accused in those cases, the co-accused have been acquitted. So that is the reason, and that context this order was passed.
But so far the present case.
Now the charge sheet only filed.
Present case is concerned, only basis of implication is the co-accused.
That's right. But why are you saying that you are covered by that judgment? That those
not a cover. I am also
in that case the co-accused who has implicated you, they faced the trial and got acquitted.
Yes, ma'am. Yes.
So therefore, the court said that they should be released on bail in that context. But here the situation is altogether different.
Here,
on you have satisfied me on merit.
Our application, I have been implicated on the basis of confession of those accused.
Fantastic ground for the purpose of getting bail. How will I quash it? You tell me. You have a case for bail, no doubt about it. But how will I quash it on that basis?
Not why I pray my lord. First or second, so that.
Come to the real point. First of all, you try to show me the judgment that is not you are not covered. Second, you have an option of going to the bail court. If the 379, why are you worried? You go and you get the bail.
You will remand the.
You get the bail 379. Why are you worried?
First or second, or I will get.
What do you say?
Well, the specific statement is that.
Is
that the above noted 4 persons along with their other associates, namely Raja, petitioner, and others also, they fled the above noted truck and sold the same at Jharkhand.
Confession.
It's all right. That's what he says. Except co-accused confession, what else you do have?
And so far the acquittal, there is no document also.
Acquittal.
What are the other evidences you have?
The investigation is going on. Page 22. The investigation is going on now.
No, charge sheet you have filed?
Charge sheet filed? Preliminary charge sheet.
22
You have filed the charge sheet?
Yes, ma'am. Page 22.
Where is the investigation going on? You have filed already charge sheet.
Subject to further investigation.
Where is that?
Last two continuing in respect of the.
But against them, the charge sheet has been filed. What is his name? Ajit.
No, charge sheet filed against other active persons.
Oh, Raja, you.
Yes, yes.
Yes.
Continuing, whatever government state, it is last
Not
line.
apprehended.
Page 22 the last line.
Against the accused.
Absconding.
23 मसीहा case था.
Absconding.
Absconding.
That's the problem. What way I can help you?
Only that. As per second.
He wants to withdraw it to surrender and get the bill. The counsel for the petitioner, although has assailed the entire criminal proceeding initiated against him in the Jauzer case number 268 of 2023 for alleged offense punishable under section so and so. However, he submits that he would be withdrawing this petition and surrendering before the court on or before 28th of February and resort to the remedy available to him under the law. After investigation, charge sheet has been filed in the present case on 21/10/2023, showing the petitioner to be an absconder, and the further investigation in the present case is also open. The counsel, it is seen from the record that on the basis of the disclosure statement of the co-accused, the petitioner has been implicated. Be that as it may, since the petitioner is stated to be absconding in the present case, I am not inclined to entertain the present petition. However, liberty is granted to the petitioner to surrender or appear before the court on or before 28th of so if and resort remedy available to be under law. If any such application for grant of bail is removed, the same shall be considered at the court below on the same day. Yes. With these observations, petition of this court. Yes.
70.
And the petitioners sought for passing of the criminal proceeding. Initially, the matter has been settled between the parties, and they have also filed a joint affidavit.
Yes.
The opposite party number 2 informant.
They are there.
They have come.
Yes. What do you say, sir?
Yes, sir. If there is settlement or comfortable.
This is dispute among themselves 420 and 506. What are the allegations, Vajri?
Allegations of taking money.
1,20,000.
1,20,000 rupees. He has already paid. He has already received.
Yes, this is money dealing between them. Yes. Who is Deepak Kumar? And Rupak Kumar?
Three is
Uma.
3 is the mother of the petitioner 1 and 2. She is 60 years of old.
But I told you have to move an application. You can't.
Yes, I will file the application.
Right. Move an application for exemption.
Yes, I will file the application.
Get that application 12 o'clock. Yes.
File.
And who is Sunadar? Sunadar means you please come.
Sundar means.
Sundar means. Sundar means. कौन ହେଇଥିଲା कौन भूल बुझाण कौन ହେଇଥିଲା केते पैसा नहीं जे माने ଦେଇଦେଲେ वापस देलेनी मारपीट करछंती मारपीट करथिले just take it up. Just check it up whether we should impose cost or okay. If they have done some physically abuse something, then they have to pay some cost. Okay. Get an exemption. Yes.
2 o'clock.
Huh?
2 o'clock.
No, 12 o'clock. You go and get an exemption and give reasoning. Otherwise, I'll reject that application and quad these 2 people, those who are appearing, I'll quad and I'll not quad.
She is 60 years old.
Whatever, you give the reasoning. Give the reasoning why
I told them to come.
It's all right. I am not saying that she should come, but at least on record, application should be there. Signed by both the sons.
Sons are there, my
Both the sons have to sign the application with affidavit and do it. Yes.
18.
12 o'clock, I'll take it up. Yes.
Yes, sir. Here is the case, my lord, passing of the proceeding. Well, the petitioner has been implicated for perpetuating, impregnated the victim. My humble submission, my lordship, my lord, in view of the present scenario, the DNA test profile has been done, which goes, may invite to lordship's kind attention to the
What is cognizance order?
yes, yes,
Yes.
my lord. My lord,
Yes.
this page is page 36, my lord. Page 36, my lord.
36, huh?
My lord.
Okay.
But 36 last.
Okay.
The opinion of the
Yes. Yes.
that from my lord. So
Opinion from
yes.
DNA profile.
Yes, yes.
Resulting of samples so and so. The accused, Exhibit C, he is excluded.
Excluded.
The biological father of the newborn female child, Exhibit B, of the victim, Exhibit so and so, because they do not share sufficient. What is this? Gentle mark what? Sufficient?
Do not say excluded as the biological father of the
Genetic
newborn.
marker.
Yes,
Genetic.
I am the that her allegation is exactly that.
Yes.
My humble submission did fix upon the modesty of the victim girl, and therefore her allegation that
376 may not be made out. 354, I don't know.
But then the age factor. She is the major. She is major.
Maybe 354.
But in one that when her allegation is
I understand you are supporting the
DNA test.
It's a 376 case. You say that because of the is it always necessary that the DNA test should be there? Without DNA test, also 376 can be made out.
Her keeping in view her allegation that that story of rape commensurate to the impregnation. That's fair. Nothing.
Well, maybe 354, not 376.
That I don't know. 354 is
354 may be made out. How do you know? How do you know?
Then you'll then that will be scaled down.
Obviously, it will be scaled down. That then the right course would be to argue at the stage of. I'll record all these things and this will be done.
You call for the answer.
Show me the allegation.
Pardon?
Show me the allegation.
Allegation is FIR.
Yes.
FIR.
Charge sheet.
Page 15 million.
Charge sheet, yes. Charge sheet.
I filed the entire charge sheet.
Where is the statement?
Yeah.
164 statement.
164.
Where does she say
Yes,
that?
yes. 164 is 32. May I invite my last conduct page 30?
Yes. 30?
32 minutes.
Yes, 32. Let us, yes, read it.
ବିବାହ ହେବାକୁ କଥା ଦେଇଥିବା ଦିନେ ବାପା ମାମୁଁ ଘରକୁ
32, huh?
ଶାରୀରିକ ସମ୍ପର୍କ ରଖି ପିଲା ରହିଲା ଦ୍ୟାଟ୍ସ ମିଲର ଶାରୀରିକ ସମ୍ପର୍କ ରଖି ପିଲା ରହିଲା so
My name is Sandhyarani, so. My age 22, my so.
Started from page 30.
30?
32. Page
164. 164 of the victim. Page 32. You got it.
ମୁଁ ପିଲାକୁ ଭଲ ବର୍ଷା
One, two, three, four.
ମତେ ବାହାରକୁ କଥା ଦେଇଥିଲା ଦିନେ
She herself says in 164.
Obliged,
She
not
says
obliged, that is.
mu chahuchi tar DNA is an accused in FIR number 4. Allegation during the investigation, the victim under 161 KRPC was taken. She had in her statement has very categorically stated that she was in relationship with the prisoner for about a year, and on the premise of marriage, the petitioner has impregnated her. She has also in her statement requested the police that the DNA test should be conducted to ascertain the parentage of the child. She was pregnant. She was pregnant. The DNA test has been conducted in the present case, and which is formed part of the charge. Charging. Mr. Thank you. The counsel for the petitioner has taken me to the latest report, which reads as under page 36. Page 36. Page 39. Page 39, last paragraph. Last opening. Page 39, last opening. Opening. By relying upon the aforementioned DNA test, the counsel for the petitioner submits that no case under section 376 IPC in any case is made out, even if the prosecution case is taken its face value. Next one. Petitioner is challenging the order dated 17/8/2023 passed by the SDGM Kendrapada, whereby the cognizance of offences punishable under section 417, only 493 and 376 IPC has been taken. Statement number 151. The petitioner has been victim prosecuted since 22 years. Since the petitioner at this stage of cognizance has challenged the seeking has approached this court, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to urge this point before the court below at the time of the framing of the charges. 493 is there. If 376 is not made out, 493 is made out. Or 354 is made out.
Petitioner has made a sacrificial lamb. That's a real culprit. He has not.
Then 493.
Yeah, that's
how we get out of 493.
But she has not disclosed the real name of the real culprit.
Then you have a case for
them scapegoat.
With this liberty, the petitioner. Yes. You argue this. May 376 may not be.
Real, so the investigation should have been directed in that after this real test.
Anyway,
the real culprit has been suppressed.
Because she in her statement, she says that
on her statement,
DNA test should be conducted.
Yes,
she was so confidently saying, and the DNA test came out to be against her. Yeah, right. Yes.
So, there are other evidence.
No, that's
other evidence.
So therefore, let
on the point, but so far, that I lordship will hold that real culprit has been suppressed. He has not disclosed. So made me as a sacrificial lamb. That is true.
Maybe. Yeah. Yes.
Some 19.
Yes.
May I please, your lordship?
You are seeking for adjournment. Are you seeking? Is it seeking for adjournment?
May I please, your lordship?
Yes.
Your lordship, before placing this matter, I would like to submit one important judgment of Honorable Supreme Court, which is very.
Let's understand the fact first.
Okay.
Yes.
Here the petitioner is seeking for quashing off the criminal proceeding against him on possession of disappropriate asset on the ground. There are 2-3 grounds, your lordship. First of all, your lordship,
Yes.
Your lordship, the FIR has been lodged in the year 2004, where the charge sheet has been filed in 2007, your lordship, and the cognizance has been taken. Now, your lordship, this is the year 2025, and no charge has been framed. No charge has been framed, and there is no proceeding has been commenced, your lordship.
When cognizance is taken?
Cognizance taken 2007, your lordship.
Okay.
Now, your lordship, if you see, there are grounds. The first ground is, your lordship, that there is a delay of almost 20 years. That is almost 2 years of decade, 2 decades, your lordship. Now, the wife has an established, there is an established business of the petitioner, which is in the name of the wife, and the wife was generating the amount, and that has been reflecting in the income tax return, your lordship. Now, the second, your lordship, is that there is a sale of a property, which is amount 2 lakh something, which has also been reflected and in the IT returns, and as well as it is a public document, which is a prosecution record as well. Now, the third is, your lordship, there is another immovable property which has been shown, that is 5 lakhs, your lordship. But, your lordship, that property belongs to a stranger person. that shall not be taken into consideration. If we calculate the total amount, your lordship, 12 lakhs plus 2 lakhs and plus 8 lakhs of the, that has been taken as a loan, your lordship, 8 lakhs of amount has been taken as a loan, and that is also a prosecution record, your lordship.
Yes.
If we calculate the three amount, your lordship, your lordship, it is in total, it is coming 22 lakhs something, your lordship. Now, coming to immovable property, if we include the entire three amount and deduct the 5 lakhs, then there will be a DA amount of percentage which is within the 2 or 2 to 3%, your lordship. Now, the relevant judgment, your lordship, please kindly see to this.
Why should the court at this stage will get into all these things? Calculation, recalculation.
No, your lordship, my only point is that there is no DA case has been made, will be made out, your lordship, because that is coming 2%, below 2%. And there is a judgment of Honorable Supreme Court, your lordship, the recent judgment.
Yes.
Paragraph 9, your lordship, please kindly come to paragraph 9. Are you there, your lordship?
Yes, I'm there.
Yes. Your lordship, here it is. The appellant's, we are in the view that the appellant's wife's income must be considered as well as while calculating the total income and assets. Both the appellant and wife have filed the relevant income tax returns in order to show their respective income and assets. So in this case also, the appellant
Let us go further.
Yes, your lordship. The respondent in this in their counter affidavit have denied these income tax returns or alleged them to be.
So therefore, when the notice was issued, the vigilance department filed the affidavit and stated that indeed it was not taken into consideration.
No.
On the basis of their admission, this order was passed.
Yes, your lordship.
You have not reached that stage. Let us then issue notice. If you can, then I can see.
What has happened in this is as far as the work is concerned.
Hey, what is the startling fact is 2004 you have registered the FIR.
Yes.
2007 you are filing charge sheet. 2007 only cognizance is taken. Today we are in 2025. You are not proceeding at all.
That is true. That is true. So far as your lordship can face 49.
49. Yes.
But my lord can submit. So far as wife is concerned, after discharge, rejection of discharge, the wife approved this under report, and this under report, considering all aspects, was convinced. And
Where is that? Where is that?
That order is reserved because this under report was inclined to interpret. So far as we know.
Then I am issuing notice. You respond.
This case is concerned, the lordship can
You say that the wife has already approached this court. In this case,
order is reserved.
I have reserved.
Nah, minor justice matter.
Then I'll issue notice. Let us stay the proceeding. Let us see if
proceeding stays.
Then it's all right. Then more of a reason that I
So
should.
my submission is wait for that. So far as the contention raised by the petitioner, that is all. Everything is on record and based on documentary evidence and
Okay.
the
Okay.
assets shown. That is
I'll just issue notice. Issue notice. Also. Counsel for the petition. Now, both the petitions right out submits that the FIR was FIR in the present case was registered on 23/6/2004. After investigation, charge sheet has been filed on 29/9/2023. When the cognizance was taken, cognizance?
Your lordship, 2007.
Date.
8/12/2007, your lordship.
Cognizance for the offences punishable under section 13(2), read with 13.
7/12/2007, your lordship.
What is the date?
7/12/2007.
2007. Cognizance has been taken by the court below on so and so for release of its punishable under section 10. The counsel for the petitioner very specifically states that till date the trial has not been proceeded, even charge has also not been framed. The counsel for the petitioner further submits that the income tax, the income of the wife of the petitioner has not been accounted for, although the wife is income tax paid.
She has relied upon the judgment of the Supreme Court Supreme Court in criminal appeal number 5009 of 2024, Nirakar Nath Pandey versus State of UP. By relying on para 9 of the judgment, para 9 of the judgment, 9 and 11 of the judgment, she submits that the case of the present petition is squarely covered by the not only the facts of the present case, facts of the case cited, but also the ratio laid down by the court below. Regarding to the fact that the cognizance in the present case has been taken in the year 2007, but the trial has not yet been commenced. Even the charge has not been framed. I'm inclined to grant interim order for stay of the trial motion till further orders. Leave the matter for final. Yes. I stayed, madam. I stayed the proceeding and.
Okay. Oblige your lordship.
Yes. But you have to prepare a chart. You say which are the properties
My lord.
of wife
My lord.
not
My
taken
lord,
into
there is
consideration. All these things has to be done.
Yes, my lord.
That exercise is there.
Yes, my lord.
Okay, then you admit it, and I'll para 9 they will directly covered by the para 9.
It's covered. I do admit, but standing this side, I can losing all my predicaments because it is come down.
You stand there by your choice what to do.
Let it will come down to 2%, less than 2%. If the asset that has been disposed of, it is part of the record, prosecution record. I can.
Let us examine. Okay. I stay with you. Okay. Yes. Yes, sir.
Here, my lord, the present petitioner challenging the order of the rejection of the, my lord, order of the Law and Trial Court of my discharge applications moved in the court below. This is a case of 2002, your lordship. FIR has been registered in the year 2002. My lord, FIR is at an annexure 1, my lord.
Annexure?
Annexure 1.
Yes.
At page number, your lordship, may.
Yes.
Page number 23. My lord, sum and substance of the allegation of the FIR is that, my lord, the FIR has been registered against, my lord, 24 persons, alleging that the law officer of a bank, my lord, he has registered the FIR that during in the year 1999 to 2002, they have, my lord, as from their audit, they can know that their manager of a particular branch, he has diverted the funds of the bank to different accounts of these 24 accounts.
Yes.
And
who are you, by the way?
My lord, I am also a account holder who has been, my lord, implicated as an accused. Against me, the allegation that there are 34,000 has been, my lord, diverted to my account. So, likewise, other 24 persons have been implicated in the similar manner. That some of the funds which ought to have been go to the bank account to the, my lord, like a
how it has come to your account then?
My lord, that is the crux of the matter. Your lordship may see the page number, the para 3 of their allegations at page number 26. It is their own admission.
Let us come to the charge sheet statement.
My lord, now,
because after investigation,
my lord, the FIR has been registered against 24 persons with, my lord, so many allegations.
In whose account the money has been transferred?
120B, 420, 467. There are other offences along with.
What they found in the
151C and PC Act, my lord. In the charge sheet, your lordship, on the annexure 2 is the charge sheet. Charge sheet, my lord, they have exonerated, my lord, 13 persons on the basis that since the amount which has been diverted, they have never been, my lord, withdrawn that amount. On that basis, though diverted fund has been made to those accounts.
But they have not withdrawn that money.
Withdrawn that.
You have withdrawn money and
misappropriated.
That is, not
that's the distinction.
Withdrawn and misappropriated.
This is the allegation. So far as the charge.
Come to page 32.
Yeah.
That's what precisely they are saying.
My lord, precise.
During, come to the page.
My lord, during investigation, 32,
Yes.
the paragraph 4, my lord.
It came to the light.
During course of investigation, it came into light that the bank is entitled to the interest for advance made to certain parties. The same is recovered by way of debit borrower's account. The debit amount is generally credited to the interest collected account of the bank, but in the instant case, interest collected from the parties were diverted in the following manner. Two instances has been given only. Not so far as how this money, when it has been diverted to my account, when it was withdrawn, it has not been explained in the charge sheet. Your lordship also.
No.
Amounts
See, the transactions are form part of the charge sheet.
My lord,
they might not have described.
My lord,
but all these things are there, part of the charge sheet.
Let me place your lordship.
Yes.
Amounts debited to parties account were not fully credited to the interest account of the bank, but certain portion of the bank genuine income was fraudulently diverted to the accounts of other persons. Means the account holders.
Yes.
In some cases, full amount of interest collected was diverted through other accounts and no amount is credited to the bank account. In certain other cases, like in generalized, they have mentioned certain other cases diversion took place.
I have seen it.
My lord. And so far is your lordship.
How will I?
Annexure 3, your lordship.
How will
your
I
lordship, see the annexure 3. After filing of the FIR, this letter has been written to the present petitioner, my lord.
Yes.
Annexure 3, your lordship.
Yes.
They admitted from the FIR itself that entire diversion, everything has been done by their manager. And by the time of registration and during the course of investigation, the manager died, my lord. He committed suicide. So matter was exonerated against the main accused, the manager, who has diverted everything. Now,
What
my lord,
is the amount in your account?
My lord,
34,000.
34,000 was initially in the FIR. My lord, in the charge sheet, they have mentioned 54,000. Now, the annexure 3, your lordship, page number 47. This is the letter which has been given in the year 2002. My lord,
Durga.
Yes, my lord. To the Durga, this present petitioner, that wrong credits effected in your account, we are desirous to bring to your immediate notice that a sum of rupees 57,000 has been wrongly credited to
Yes, Mr. Naik.
These are the matter of trial. The authenticity of this document.
That's right, but see, the small people, 54,000, 34,000, why are you after them? You have big investigation.
Your lordship,
2002, my lord, FIR.
Wrongly credited, he has withdrawn it. That's the fact of it.
Your lordship, whether it is wrongly credited or not will be decided at the stage of the trial.
But technically, you are 100% correct. I am with you. But
Your lordship, in this case, your lordships,
trial has not yet been commenced.
Your lordship, he is challenging it because your lordship, now the trial has been split up. An imbue has been issued against him. He should have gone for anticipated bail. Yes, your lordship. He's not speaking
discharge. Okay, type of discharge only. When I moved, discharge petition was rejected, and immediately he has issued on the.
I'll tell you, this may not be a case of discharge, but the fact remains that the amounts are very small.
Milord,
and how many people are prosecuted?
Milord, now they are prosecuting against 12 persons. When the manager himself, all the Milord vouchers, how they diverted, because it has been entirely explained that diversion cannot be.
Everything is interconnected, you know.
Diversion cannot be made.
If when one person is discharged, the entire case will.
Milord, the diversion cannot be made without the concurrence of the manager, who has already been died. And all the withdrawal slip and the diversion slip, it is not with the domain of the present petition.
We'll see. I'll just, Mr. Naik, I'll simply issue notice. I'll not say anything. I'll simply issue notice. Let us examine.
Yes.
Simply, I am issuing notice.
And so,
because for accused, then
his amount may be small.
The entire prosecution of the CBI will be collapsed if I cut in between.
Milord, 2000 is the charge sheet. 2005 with the cognizance.
Let us see. Let him read. I'll just issue notice.
His amount is small. If cumulatively we take all the amount, it will be big.
I understand that. That is the reason I'm saying. If I quash it, it have a cumulative effect on other accused persons. I can't do that unless I see where the route goes. Let us examine it.
My lord.
Because of the amount, I'm just.
Yes, your lord. And at that point of time, petitioner was also a student. He was nothing. He has not signed any signature.
I put into it. So that's the reason I have a sympathy. But the problem is, if we quash it, Mr. Naik is absolutely correct. It will have a cumulative effect.
My lord, only one miscase so far as the NBW is concerned, my lord. Your lordship.
Surrender. You surrender. Learned counsel for the petitioner issue notice for the learned counsel for the petitioner submits that at the stage of framing of charges, NBW against the petitioner has been issued. On instruction, he submits that he would be appearing before the court on or before 28th of February.
1st March, your lordship.
1st
is
March, okay. 5th March, okay.
Yeah.
5th March,
Right.
so and so, entry showed to the remedy. Till then,
Your lordships,
NBW.
your lordship, he has an alternative remedy for filing.
All right, Mr. Naik, let him go and appear. You are one of your officer will be unnecessary engaged for execution of NBW. He is saying he will appear. Why are you unnecessary?
Yes, your lordship.
Let him go and appear.
To which Mr. Naik objected, your lordship, one line may be added.
Your officers are better works to do.
Yes.
Why after the small man?
Lordship, I record my objection only. One line.
Yes, yes. Execution of NBW against the petitioner is stayed till 5th of so Mr. Naik, Mr. Naik has vehemently opposed the cancellation of NBW on the ground that it will have an implication in the trial, and the petitioner is deliberately avoiding the process of the court.
Yes.
Page 14, order dated 9/5/2020, 2011. The petitioner was allowed to go on bail, and your lordship at page 17 on 23/2/2024, NBW has been issued.
Okay, 500. Yes.
22.
Aji, 5th March.
Item 22. On
Yes, sir.
8/11/2021, BLAPL number 21,591/2011, my lord, pay number 25, your lordship might kindly see.
Yes, yes.
The petitioner was on bail and order dated 19/2/2013, my lord. Now NBW issued against the petitioner.
2013.
19, yes, my lord. 19.
Yes, sir, 13. 4
2013.
petitions are there.
1,000 each.
4,000.
1,000 each, burger. Burger bar. Yes.
23.
May I please, your lordship?
1,000 each.
May I
Yes,
please, your
yes,
lordship?
madam.
Hello, this is a Belgium matter, your lordship. The petitioner was on bail from 14/12/2016, your lordship. 15/12/2016, and NBW issue against the present petitioner 23/7, your lordship, 2024.
24. Okay. 500 each.
Obliged, your lordship.
My lord, NBW was issued on 18/12/2023, order number 13, and previously he was on bail on 8/8/2023.
Okay. 500.
25.
Vigilance matter. Belgium matter 317, as well as time petition was rejected, and NBW was issued on 13/12/2024 also. Lordship. The petitioner was on bail, your lordship. He was on bail on 15/9/2003.
59.
Vigilance case, your lordship.
Okay, his vigilance matter also.
500.
26.
And here is the case just different. Petition was not released on bail, your lordship. NBW issued on 17/8/2024.
On the
My lord,
on the prayer of IO. On the
My lord,
prayer of IO.
what has happened, my lord? My lord, in this case, two accused persons were there. Both of them approached this honorable court.
Okay, charge sheet has been filed on.
My lord, lordship may kindly peruse, my lord. Both of them approached this honorable court, my lord. This honorable court granted anticipatory bail to both of them. Prior to charge sheet.
I'm cancelling a bill.
My lord, in charge sheet, my lord, 307 has been added. Higher offense has been added. So
You're absconding.
No, he could not surrender due to that 307.
Outstanding.
Yes.
Madam, charge sheet has been filed in the present case on 19/9/2024, showing the petitioner is an absconder. Absconder.
The other person has surrendered and he has been released on bail.
That, a higher offense of 307 IPC has been added in the
Charge sheet.
Charge sheet. The co-accused persons have already been
Released on bail.
Enlarged on anticipatory bail.
No, my lord.
Released on regular bail.
Regular bail. He has surrendered and
Regular bail. Co-accused person, namely, Anil Kumar Giri and
Anil Kumar Giri khali. Ye hala Jadumani.
Anil Kumar Giri, after surrendering before the court, has been admitted to regular bail. Regard being head to the above, the NBW issued against the petitioner is by order dated
17/8/2024.
17/8/2024 is set aside, subject to the petitioner appearing before the court on or before 5th of March and issued to the needless to say that the petitioner, it is open for the petitioner to raise all the points, including the point of including the ground of clarity. Including the ground of clarity.
Same day disposal by both the courts, Lordship may say.
It is expected that the bail application can be disposed of on the same day.
Same day. By both the courts. By
both the courts.
Till then that NBW.
Yes. State, I set aside what to say.
Yes. Obviously.
Subject to all these things.
Obviously.
Yes.
27.
And paying cost how much?
For a parity, my lord.
That also I said. The cost. Pay the cost. Now, because you are appearing, you're supposed to send the juniors 1,000 rupees. High Court bar. Okay.
500.
No.
The labor, my lord.
Why you are appearing then? 1,000 to the High Court bar. You should have sent your juniors. Yes.
27.
So learned code below, Lordship may say.
No, let it be High Court. Because you have committed a mistake here in the High Court. So therefore let it go to the High Court.
Item, pardon to mention, my lord. Item,
yes, sir.
item 17, my lord.
1 minute. We were searching you, all of us. Wait. 1 minute. Let me take it after 33. Yeah. Bail matter. Wait for 1 minute. Yes. Yes.
Please, your lordship. Your lordship, quashing of the order dated 19/8/2023.
19/8/23.
Yes,
Okay.
your lordship. Issue NBW against the petitioner in GR case number 4 to the 4 of
Bail.
Date has not been mentioned in paragraph 2. He has written that released on bail.
Achha.
Yes, your
Released on bail for the 500. Yeah, 500. Okay.
28. Please, your lordship.
Yes.
There has challenged the order dated 13/5/2010 regarding the quashing of NBWA. This is case number 135 of the election.
Municipal 2008 NBW 2013 5 2010 1000 2010 1500.
My lord, the petitioner is 61 years old. Petitioner is 61 old person.
Yes. I have allowed. Yes. Next.
Yes, my lord, local bar. Kindly local deposit in the local bar.
Yes, local bar only.
Yes, public.
Baleshwar bar.
Yes, ma'am.
May I please, your lords?
Yes.
NBW, Belgium case, my lord. NBW dated 21/12/2024, my lord, page 10. And where
24, okay.
21/12/24, my
Okay,
lord.
bail.
Bail, my lord, petition number 1, 19/4/2019. 2 was on 41, my lord. Ladies.
No, 2.
Petition number 2 was on 41, my complaint.
41. Petition number 2 was under the notice by the police under section 41 C, and petition number 1 was to bail
on 19/4/2019.
NBW
NBW 21/12/24.
21/12/24. Okay, 500 each. Yes. Yes. 30.
Bail was granted on 5/12/2020.
Yes.
And NBW issued 28/6/2016.
16.
My lord.
Your
5/12/2015.
15.
1,000. 1,000 is West Bengal one. Which police station? Angul, Angul bar na?
Angul.
Angul is the local. No, Angul bar. Angul bar. 1,000 kodi. Yes. Next.
31.
Actually, 4/9/2021 बेल 26/3/2022 एनबीडब्ल्यू.
Okay, 500.
52. May I please your lordship? My lord, 29/10/2007 release on petitioner release on bail.
32.
My lord. And 10/7/2024 NBW issued by the trial court.
500 each.
Obliged.
53, my lord, NBW issued 6/11/2024, my lords. But petitioners were on bail, my lords. Your
Date, do you have the date? No.
My lords?
Do you have the dates?
No, my lords.
Yes.
But
Okay.
petitioners were on bail, my lords.
24, 500. Yes.
10 accused persons, my lord.
10?
My lords.
All right. 500 each karo.
10 जन total
Puri.
गांव लोगों के.
Puri, 500 each, Puri bar. Yes. Call them. Yes.
70.
Yes. Party number 2, FIR number 20 registration of the petition and allegations below. The parties are presenting the court below. For the representatives of the state council, filed the use of court. See paragraph below. After investigation, charge sheet in the present case has been filed on the 31/5/2019. 19 for late commission of offense. Cognizance has been taken.
My lord. 17/12/2007.
Commission of offense under section 420, 294, 323, 506/34. Read with section 30, section 3, bracket 1, X of SC, ST, POS, POS, X, POS, POS. That is present in the court. The petitioner number 1 and 2 are present in the court. Okay. In the court represented by the and opposite party number 2 is also present in the court and represented by the council and identified the separation copies. However, so far as the petition number 3 is concerned, petition number 3 is not present in this court, not present in the court, who is the mother of petition number 1 and 2. An application is moved on behalf of the her seeking exemption from appearing in the court. For the reasons stated in the application, the claim is allowed. The physical presence of the petitioner number 3 in dispensed. Cognizance has been taken? No. Cognizance, charge sheet is filed or something. The cognizance of the opposition statements and has already been taken by court will. However, the charge has not yet been framed. Before the
Trial is going on.
Trial is going on. You have not said anything when nothing is filed.
Because
that's the whole difficulty. That's the very pathetic story of this court.
Only one.
Nothing.
Only one witnesses have been examined.
I don't tell me all this thing. You are filing something for quashing. And what is the stage? Only charge sheet is filed. You have not filed anything except that.
Sorry.
What is the stage of the...
Now only 1 or 2 witnesses have been...
I don't know. I can't scuttle the trial like this.
Because in the meantime, as because settlement...
What will happen, try to appreciate. These kind of offenses, investigation over trial is going on. Evidence is being recorded. You don't tell anything and file a 482 petition. I quash it. Am I not interfering in the and scuttling the trial? Is it permissible under 482? I go by your face value. Whatever you say, I go by that. You have filed FIR and charge sheet. I am under the impression is charge sheet is filed. So trial has not been commenced, so I will interfere. Just imagine a situation if the trial is at the fake end. Evidence is recorded. How can I interfere in 482? How will I know, sir? How will I know? You tell me.
If you don't, I have to believe you. Whatever you say, you have not said anywhere. You have not filed anything. And you are giving an impression to the court that this is at a very threshold.
Yes.
And you have settled the dispute, I interfere and quasi. But it is so dangerous. You can't do that to the court, please. You file an affidavit. I will not do that. File an affidavit. You tell the status of the case.
I will at the initial stage, my lord.
I don't know, sir. I am asking cognizance order. I am not sure whether cognizance is taken or not.
Yes, cognizance.
Where have you said? You tell me.
Yes, I have.
Where is that cognizance order? Where is the charge order?
Cognizance, your lordship, I have paragraph 3 I have stated.
Where is the charge order? You have not filed anything. This is very pathetic.
Cognizance has been taken, but trial was not commenced recently, or only one.
When the charge is framed?
On 17/12/2019. Cognizance was taken. Paragraph 3 I have.
Where is the charge? Charge order. When the charge is framed?
Charge order section 420.
No, where? When the charge was framed? When the charge is framed? 2019 cognizance is taken.
Yes.
When the charge is framed?
Recently, sir.
Recently means?
Not to the date.
During
Half an hour back.
2000.
Recently, half an hour back also.
2020.
Where from I get it? See, this is a court of record. Why don't you understand? We can't do injustice to the proceeding. Please make things very clear. Otherwise, it will be in a travesty of justice. Have you ever approached this court for passing anything earlier?
No, man.
You please file because see, it is not in the interest of the proceeding, in the not interest of you also. It looks like a misleading petition.
Only monetary.
I understand, but what
they have already settled the matter.
Maybe, but if in the advanced stage of trial, I can't do it. That's not the law. You can't scuttle the trial in this fashion. I'll put it next week. You please clarify, and I'll do it. Okay. Print out
next week.
You do it, file. You tell how many witnesses are there. All these things are very necessary. How many witnesses are there? How many witnesses have already been examined? When the charge is framed? What is the stage of the trial? And what stage you are approaching this court?
Yes.
This is minimum. Thereafter, I'll interfere or not interfere. That's a different story. But record has to be very clear. You do it next weekend. Okay. And you take all these things and file. This IA has to also numbered. Give it. Give it back. Give it back. File a detailed affidavit, stays and everything, you tell me. Okay. Next.
34.
Based on the section 3.
4 items. B is to require. Just now I have received the deposition copy. I have to go to the
Yes, which one? Learned counsel for the petitioner state submits that he has received the copy of full deposition today and hence seeks an adjournment. Please the matter of week.
Next week.
No.
35. Please, my lord.
My lord, Mr. Pangres has some problem personally. His wife, his mother has a illness.
Due to
listed as too much.
Ground of personal difficulty, learned counsel for the petitioner seeks an adjournment. Leave the matter of 2 weeks.
36.
Pastor.
37.
Yes, sir.
May I please, your lordship? My lord, on the last occasion, my lord had directed the state council to obtain CD, my lord. The bail application was earlier rejected by your lordship.
Yes.
And it was rejected, my lord. And while disposing the earlier bail application, my lord was pleased to order that after examination of some material witnesses, the petitioner is at
I will pass the same order.
My lord,
I will pass the same order.
my lord, in the meantime, the father of the deceased has been examined.
Only father.
Father and other 6 witnesses. I have.
Where is that? Where is the deposition?
My lord.
That is right. No, he says that the material witnesses have already.
The IO only, because 161 is recorded by the IO.
No, he can't be a material witness. IO can't be a material witness. IO is, then if you say IO is a material witness, then every accused has to wait till the last witness is
Yes,
examined. IO is examined at the end.
Because of
Again.
this time declare 151.
You just see, you just check it. Give a copy to him.
I have already given.
Have you seen it?
Just now he has given.
7 is
I put it. All are hostile. So then, what? Who all are the other witnesses you have?
My lord, the neighbors have been examined, my lord, 1 to 7, and 7 is the informant, father of the deceased.
No, any eyewitness, anything?
My lord, eyewitness have been examined.
Who is
the neighbors, who are the family members.
Who are they?
PW 1, 2.
1, 2.
They are the neighbors, my lord.
Will you check it up? All the witnesses? None of them has supported. At least he is entitled to bail. Shall I pass it over?
My lord.
Custody since?
My lord, I am in custody, my lord. 16th March 2024, my lord. 16/3/24.
16/3/24.
My lord. Out of
See, none of the witnesses have supported so far. Only witnesses are there. Just
my lord, only the informant has alleged against the present petitioner, the father of the deceased. Only 7, and others are not alleged. And
yes.
Paragraph 2, after 15 days of marriage, the deceased called me over phone to come to our matrimonial.
It was of the year 2015, my lord.
Demanding some idea of the liability. After some days, demanded some more money, construction and renovation of the. Thereafter, 3 months, suffering born injury on August 2007, while on treatment at
My lord.
So demand of dowry only.
Yes.
But where is 302?
in view of the statement of.
This will be at best section 4. DV 498 maybe. Very 302.
The present petitioner is the husband.
My lord, on the date of occurrence, he was in his
Yes,
duty.
it's 307 to 302.
Right.
There is a statement of 161 of the. In presence of the minor, the record, the statement is recorded by the SI sub-inspector of Hon'Ble. And 106 is well made out against the present petition. If you also consider the bail application.
So you read it, but I think he is entitled to bail. I think you read it, I'll put it next week. Huh?
Oblige, my lord.
Place it on record. He is entitled to bail. Then the only strength you have is that 161 statement of the deceased who died subsequently. That could be a dying declaration under section 32. That's the whole thing. And this has been done by the police.
While you are treating.
My lord, FIR has been lodged after 46 days of the alleged incident. And I admitted the deceased in SCB Medical College, Cuttack, but the informant interfered and he took the deceased to different nursing homes. So this is the whole cause of her death.
You are entitled to bail, sir.
Oblige.
Just I'll keep it next week with the procedure. 12th, huh?
Oblige, my lord.
39.
Limitation and
Sorry, sir?
to file a better affidavit.
Yes.
It was. I have filed the requisite. Some of the respondents are appeared. Sir, back. Some of the respondents.
No notice has been issued. Huh?
Notice has been issued. Some has not appeared. Notice are sufficient. Mind.
7 appeared sufficient. 1, 2, 8, 9. Without instruction. 4,
Take fresh steps.
My lord, I have a suggestion. The first of these are automatically transferred by notification dated 27/9/2021. All the first of these are transferred to the district judge.
Restore kale padego. These are
automatically
restoration.
Restoration helle first of bill
Where is the delay? Delay application.
Delay to 30 days. I have filed the better affidavit.
Yes,
so lordship directed to file better affidavit. I have filed.
What do you say? Who is there? Nobody.
Nobody has appeared. First of bill पढ़ो सब automatic एटा लिस्ट भी हला भूल ले.
Because dismissed by this court, so therefore it has to be.
Default hela एटा without transferring it, it was listed.
Right.
Unnecessary appear करना तो unnecessary linger.
Notice was issued in the present petition. Service of the notice that
Notification dated 27/9/21.
Also is complete. Whereas the insurance also are concerned, the postal remark received by the postal remark indicates that all of them left. 11 pieces. No, address left here.
367 complete. 11 deceased others.
18 not way. The counsel for the petitioner submits that in so the restoration of what?
Restoration of appeal, my lord.
The appeal. That appeal is transferred. All the appeals are transferred.
My lord.
All the appeals are transferred.
Yes, my lord. All the appeals are transferred.
Which is that appeal? Appeal number? Appeal number? RFA. Why it is transferred?
Transferred to respective decisions.
Why?
That a High Court circular, my lord.
Acha. Can you
27/9/2020.
Can you give me that circular? Do you have?
Not here, my lord. I will give you.
Persons to the submit that persons to the circular.
Notification dated 27/9/2021.
27/9/2021. All the regular first appeal of the similar nature have already been transferred to the district courts. Therefore, he submits that the RFA number 202 of 2024, which has been dismissed for non-prosecution by the order dated.
Non-prosecution dated, my lord.
By order
29/3/2023.
Order dismissed on that day.
My lord.
29/3.
29/3/2023.
23 may be restored to its original file. So that the claim could also be transferred to the district court. District court pursuant to the notification of the court dated also for nice also.
Second,
the present CRMP is suffering from delay of
230 days.
230 days. Hence, the present application has been moved. Conveyance of the moved. Pursuant to the order of this court, the petitioner has filed a additional affidavit dated 15/1/2025, explaining the delay caused in filing the present petition. The delay is explained in para 3 to 7. 3 to 7. Regarding head to the aforementioned cause offered by the petitioner regarding the delay, I'm inclined to allow the application. The application is allowed. The application is allowed. The main petition is executed. The main petition is also entertained. And for the reasons stated for the regarding head to the submission made by the council, as mentioned above, the petition is allowed. The RFS also is restored to the original file. Yes.
Second is same. Second another first. Second.
Same.
Only RFA number will be.
RFA number is same. Okay. 40 भी
40.
Similar. Yes.
41.
I'm at a BC. It is dismissed for default, my lord, on 6/7/2023 due to slip of eye, could not able to appear on the day, so dismissed for default. It is time with no delay, my lord.
No delay. Yes. For the reasons stated in the application, what is this? Application for restoration. The restoration, the same is allowed. The order dated 6/7/2023. 23 is recalled. CRLMC 26323 of 2020 to be restored to its original file and release the matter, release the CRLMC for hearing on such issue. Yes. Yes.
42.
Can be disposed of.
Yes, sir.
Your lordship's order.
You changed it, huh?
Lord, FAO. Lord, 3 amendment application, your lordship may allow it, but a date.
You are appealing for whom, ma'am?
Appellant.
Appellant. You are for?
I am for the claimants.
Very good. So, allow. Yes. Appellant. Presence lagana, don't.
My lord, there are 3 amendments. Amendments. One day was
you have, I think you have written in the pencil.
No, I'm in the main petition. One date was mistakenly typed out. They have filed 3 amendment applications.
Here.
Here. For correction of that date.
All the applications are allowed. All the applications are
allowed. He will correct.
The typographical error pointed out by the petitioner in the present appeal.
Well, he may be allowed to correct.
Stands corrected, and thereafter pass this out. Yes.
delay may be condoned.
Delay. Yeah.
Yes. Original file है अच्छी कितनी? Hard copy अच्छी? Paperless, otherwise it could have been. You correction would have taken over. Correction. Yes.
43.
Same. Have you changed it? You are appealing for it? 43. And ऊपर लिख दिया 43. 43. Okay. Yes. 44 also. Why these petitions are pending for such a long time? What is the agreement then? 13 lakhs. Good that matters are being settled. Always better.
Hardly 10% cases are contestable. Otherwise, rest of the matters are.
It should be disposed of like this.
Quantum disposed can be disposed.
Yes, definitely. It's unnecessary burden on the court.
10% cases are there where contesting.
There is a contest because there are legal issues are involved and all.
90%.
Because it will have an implication in other cases. Therefore, it has to be decided.
Other 90% cases can be disposed.
Mainly,
you give the number so that we can list it and
yes,
give it to our court master if you have.
In these cases, mainly substantial question of law to be seen. But 90% cases are no substantial question of law, only quantum dispute. They are coming.
Quantum dispute one.
Can be settled. Yes.
Can you please give the FAO number?
Yes, we will provide the number to the bench.
नहीं सब लोग ही दियो कल्याण नहीं जहाँ देबे से वर्कआउट कर दियो लोग ठीक है yes yes sir.
45. Individual lordship.
My lord, dismissed for default, my lord, and I mean, pardon due to my laches, the case has been dismissed. No delay, my lord. No delay.
So, what is this matter?
Restoration. For restoration. Say 2078 of 2022.
Due to my mistake, my lord, I could not act.
711.
Yes. Okay, allowed. For the reasons. Yes.
Good.
46.
Decision behalf of Mr. Rai.
Modification of order only.
What modification, sir?
PS number 18 para 18 of the order. Instead of
Judgment.
trial court.
Judgment is.
Judgment.
Yes.
The lordship is directly for compounding of the offense before the trial court and proper section.
Trial court as well as the authority.
It's competent.
Authority also trial court, the jurisdiction of trial court under 320 will not be taken away. If you want to do it before authority, do it. I'll add that also. Right. Where is that? Para 18, para 18 of the order dated 23/12/2024.
Page 21.
The reasons stated in the for the reasons stated in the application is allowed. Para 18 of the judgment dated 23/12/2024 stands corrected in the following terms. Replace करो ये paragraph, ठीक है? In view of the same, the petitioner is granted liberty to approach the competent authority. Under competent authority, have you described under the act? Describe that notification. It is notification. Statute. Competent authority, liberty to approach the competent authority or the learned trial court under appropriate provisions of law, seeking compounding of the offence, relying upon the circular dated 17/10/2024 issued by CBDT. Full stop. If such application is moved before the competent authority or and obligor before the competent court, the same shall be considered on its merits without being influenced by the observation made by this court in the present order. Replace this paragraph. Okay. AFR, otherwise also everything is AFR. Judgment is pronounced long back. कर दो AFR कर दो, replace करो. ये paragraph का replace करके AFR करो.
Okay.
Yes.
47.
No, 1 minute, Mr. Kedia. Then para 17 also has to go. Resort to the procedural remedy. Para 17 में लिख दो कोरिया पड़ियो भैया. It says it may be invoked the in that view of the matter, the petitioner may resort to the procedural remedy under 320 CRPC by relying upon the circular. There also you have to change. Operating para procedural remedy para 17 repeat लिख दो. ये under section 320 काट दो. Para 17 and 18. ठीक है? Procedural remedy.
Your Lordship, on behalf of Amalan Suktipal.
Which item?
Item 47.
Read that. Wait. 46. Wait. It is procedural remedy under section 320 CRPC लिखा है ना? 320 CRPC काट दो. Para 17 and 18 changed, huh? Okay. Procedural remedy means it covers both. Whatever procedure is there. Okay. 320 cut out. For the reasons stated in the application, the paragraph 17 and 18 of the judgment shall be replaced by the following paragraph. Yes, 47. Yes, madam.
Your Lordship, the present application filed for modification of the order dated.
What modification you want?
For modification of order dated 11/12/2024, wherein the petitioner was directed to deposit 7,50,000 rupees, but the petitioner are unable to pay such an amount. Let the amount be reduced to 3 lakhs of rupees and along with property security be directed.
See, that's the idea is to pay the money so that it will be utilized for the upkeeping of the cattle.
Your Lordship, the petitioner is unable to pay such an high amount.
Court has directed to pay 15 lakhs 8,000, where this honorable court has pleased to pass 7 lakhs.
4
Yes,
lakhs.
yes, my lordship.
And property security be directed, but the amount will
It's not a matter of property. It is the money will be utilized for the purpose of upkeeping the cattle.
Yes, Your Lordship.
Property, what will they do with the property security? They need hard money, hard cash for that.
Amount be lessened.
It is not a bail condition or something of that sort.
Your Lordship, the amount be lessened. 3 lakhs or.
The order was 15 lakhs. I have reduced down to 15 lakhs 8,000. I have reduced down to so much just 4 lakhs. I can't. I don't.
4 lakhs of rupees.
I don't. I don't. The petitioner is seeking modification of the order dated 11/12/2024 passed by this court, whereby the amount of whereby by relying upon the judgment of Dhyan Foundation, State of Orissa, passed in CRLMG number 5310 of 2023. The amount directed to be deposited, amount of 15 lakhs 8,000 directed deposited to child court is reduced down to 7 lakhs 50,000. 7 lakhs 50,000. The counsel for the petitioner submits that he is ready and willing to furnish 50% of the said amount by property security. Property security. I'm not inclined to entertain this application because the amount to be deposited would be utilized for the upkeeping of the cattle seized in the case and lying seized. And moreover, the petitioner, moreover, liberty has already been granted to the petitioner to approve the trial. Yes. By the said order. Yes. I have given the liberty. If such application is moved, you can move an application there in trial court. You should have moved. Liberty is granted. Yes.
Obliged to. May I please, Your Lordship? No, notice of this. So last occasion, she has received, the opposite party has received the notice.
Notice is sufficient. I'll pass it over. Let's see if anybody can. Yes.
49.
49 এটা order dated 10/1/2025. This honorable court quashed the NBW. But to seek appropriate remedy subject to payment cost of rupees 1,000. ସେଠି ଲେଖା ହେଇଥିଲା ଯୋଉ ବାର ଆସୋସିଏସନ ଘାସିପୁରା, ସେଇଟା ସେଠି ଘାସିପୁରାରେ କିଛି ନାହିଁ, ବାର ଆସୋସିଏସନ ଆନନ୍ଦପୁର ସେ ଆକ୍ସେପ୍ଟ କଲେନି ସେ ପଇସା। ଆନନ୍ଦପୁର ବାର ଆସୋସିଏସନ ଆନନ୍ଦପୁର ହେଲେ
Anandpur could be. Yeah, order dated 10/1. That's another problem. Every order I have to see myself. I don't know. There is a they might have seen the FIR and might have written. District Bar Association. Ghasipura, there is no bar association at all. Where will they? Anandpur? Anandpur
Bar Association Anandpur. A welfare fund confused.
For the reasons stated in the application, the claim is allowed. Petitioner is allowed to the order dated 10/1/2025 is modified. The petitioner is allowed to directed to deposit the cost of 1,000 rupees with the advocates welfare fund for District Court Anandpur.
Bar Association
Anandpur, and the time the time granted to the petitioner to surrender or appear before the court is extended.
Time to action
5th of March.
Direct order man kindly see the annexure 5. Direct order. This honorable court grant 42 page.
Yes. What do you want?
3870. And to para 3 miler. 3, 4, 5, 6 miler. Direct order.
That can't be. In cancellation of NBW, how can I say they shall be released on bail?
Another case 40, 50
maybe, but
item 50 so 307.
I don't know what is the case, what weighed in the mind of the coordinate bench.
307 ରେ ସେ ଏଇଟା ଚଳିଯିବ
and it directly
ଏଇଟା 307 ଅଛି
he shall be released on bail. How can I say on merits the court has to consider? I can only say that your application may be considered on merits on the same day.
Same order.
No, shall be I can't do because I don't know what is the fact of that case. Maybe was he on bail? You are also in bail. You are also on bail. You are also on bail. You are also bail. Issued to the surrender before the court on before 5th of March and issued to the remedy available to him under law. If any such application is moved by the petitioner for a grant of bail, the same shall be considered. You are on bail now or not? We are already admitted to bail.
হ্যাঁ বেল কিন্তু সরেন্ডার বেল ডেটেড মেলট বেল অর্ডার annexure 2
You are on bail or not? You tell me.
বেল রে সে ডাইরেকশন দিতে সাবজেক্ট টু আরেস্টিং অফিসার ইন দ্য ইভেন্ট অফ আরেস্টিং অফিসার আমি সেটা সরেন্ডার করনଥିଲି
Bail, already you are there. Shall be considered on the same day, keeping in view the order dated 23/2/2021 passed by this court in ABPL number 998 of 2021. Okay.
But another 307
What is your problem? You want to solve every problem in this petition.
Item 50.
This problem, this is over. This is over. Shall I close it now? Okay. Next. Okay.
50 মেলে সে বার আসোসিয়েশনটা সেটা ইয়ে হবো আর প্লস ডাইরেক্ট 307 টা আছে তো সে এন্টারটেইন করবে
30 Susila Agarwal.
মানে
Susila Agarwal judgment is there. You are already on bail. Then Susila Agarwal will help you. You will be released.
ସେଥିରେ ଲେଖା ହେଇଛି ବେଲ୍ ଅର୍ଡର ରେ 16 କାଇଣ୍ଡଲି ସି ଦ 16 ପେଜ
Same कर दो. Taking to
cancellation
bail application.
violation of any of the
Consider in the light of the order of the coordinate bench stated 20/2021 passed in ABPL number 15517 of 2020. ठीक है. Okay, done.
cancel direct order
I've done it. You read, yes.
51 ଟା ମାଇଲ
Same.
ସେ ଖାଲି ବାର ଆସୋସିଏସନ ଟା ରହିବନି ବାର ଆସୋସିଏସନ ଭଦ୍ରକ ସେ ଅଲରେଡି ଡିପୋଜିଟେଡ
Deposited.
ହଁ ଦେଇଦେବି
The same accused or what?
ମାନେ
Accused is same.
accused another accused PS case GR case all are
Bar
same
association, Kotra Bar Association, he is already extension of time.
ବାର ଆସୋସିଏସନ ଟା ଦରକାର ନାହିଁ ବାର ଆସୋସିଏସନ ଭଦ୍ରକରେ ଡାଇରେକ୍ସନ ହେଇଥିଲା ସେ ଡିପୋଜିଟ କରିଦେଇଛନ୍ତି
Extension of time for the reason stated in the application, the same is allowed. The time to extend, one time to surrender, appear before court is extended up to 5th of March, and resort to remedy. So, if application is moved, the same shall be considered in the light of the order dated 20/1/2021 passed in ABPL number 15519 of 2020. Okay.
53.
Okay.
One minute. Yes. 56, huh? Yes, sir.
Give me password.
Requisites has not been filed. Huh? Notes of submission. List it up. List it up. Yes. Next.
54.
Simply 50.
54.
Item of 54 can be taken up tomorrow, Your Lordship.
Not
Mr.
tomorrow.
Pal is not there.
No. Either today or I'll vacate this stay order. Not, this is not the way. The court can't adjust according to your table, according to your routine. You 2016 matter you have taken stay now asking for. You are appearing.
54, Your Lordship, may adjourn to some other time.
Hey, why should I adjourn 54, na?
54, Your Lordship.
Why should I adjourn, sir? It is 2016 matter. You have taken the stay now for some context tomorrow, midnight. All these things, what is going?
Your Lordship,
I'll vacate the stay then. I'll vacate the stay. This is not done. I will not entertain like this. See, 2016 you have taken stay.
Your Lordship, kindly last.
No problem. And first matter you come and appear. And old matter, I will vacate this stay, then you argue whenever you want. I will not wait like this.
Lordship, as a last.
Pass it over, pass it over. No chance. Pass it over. Otherwise, I'll impose heavy cost. You pay 10,000 to the bar.
Lordship, kindly pass over.
I'll pass it over. What is this? These 2012, 15 matters you have taken stay against cognizance order, against charge order, and you are asking for time routinely. Yes. 53, he was asking for time. Written submission has not come.
53.
Last time
My lord has not. Highly also the disposed of by my records also disposed of.
Post of?
No. Well, it requires a dead chat only, no written submission. Yes, I will prepare a short note if my lord
next week. Next week. This is also
my lord may bring the file. I have also prepared it because
you have not, you don't have a file.
The short point involved in the case.
Like has indicated that my office has indicated that on 27/3/2023 it is disposed.
No. 20?
27/3/2023.
No. It was last listed on 27/3. This means for non-prosecution.
Restored.
Stands vacated. And that is restored thereafter.
Restored.
Justice Mahapatra is restored it.
First file the file and copied.
It was dismissed in default.
My lord.
And thereafter Justice Mahapatra is restored it. That is how this matter came.
My lord.
Okay.
What is short?
Simply.
I will fix up a date, so short date, 11 or 12.
What a copy. What a copy.
Also, it's a copy.
First week. Yes, first week March record because he doesn't have the file. And entry mode to continue. Yes.
Entry mode to continue.
Yes.
55. 55 by lord.
55 your lordship is called for.
LCR was called for, my lord. In this case, my lord.
LCR is called.
In here?
Your lordship kindly seen the
57, 55.
Order dated 13/11/24.
13/11?
24, my lord.
58 man. Make it 58. 55.
The scan copy of trial court record.
My lord.
Is called for. Is there? It's there already. Yes. Yes.
Lordship, by praying, my lord.
This has come in December 24.
If your lordship desires, we can have a copy to ably assist the court.
No, that's right, but your junior should have taken it.
Yes, my lord.
Why have you not taken?
Direction is required.
ଆସିଛି କି ନାହିଁ ନା ଆପଣ ନକଲା ଯାଏ ସେ ଦେଇପାରିବେ।
Flag C, submission scan copy of ice so and so, reference report so and so. Scan copy. It is there. It is already there. Just see the mail. You have to download it and then scan it. Mail taku scan kar dijiye.
मैंने आसी नहीं सी।
What happens is through mail it has come. You have to download, then you have to scan the. Instead of that, what they did is the mail itself they scan it and put it.
वाह अरे साइंस क्या डेवलप कर रहा है।
These two files that you have to download it, and that downloaded copy has to be scanned.
Why your lordship had called for the LCR? Because of there are some.
Let the LCR come. Pursuant to the order dated 13/11/2024, the trial court has transmitted the scan copy of the record of to the court below. However, the same has not been uploaded in the record of this court. The registry directed to do so, and copy of the petitioner is at liberty to inspect the record and avail the copy of the proceeding of the court below. Release the matter on so and so for entry.
Presence may be recorded.
Entry model.
We will use the pen drive, my lord.
And do it not on the day of hearing. You take it. You should have pointed out to the registry then. That is how it is done. Yes.
ସେଇଠୁ ନେବୁ ନା? ଆପଣ ଦେବେ।
Yes. Yes.
56.
These very old matters are unnecessary. Pass over.
56, 7.
57, 56. Yes. 58. 58.
Please.
Yes, sir.
58.
Yes.
I'm appearing for the OP number 2.
58. Somebody else is appearing. Someone.
For the petition.
You are for petitioner.
Yes.
Okay. Yes, sir. What is this?
This is a petition. It was the order of cognizance passed in 1CC case number 143 of 2022 on 25th of 11, 2022. Therein is, it is a civil dispute and the cognizance taken under section 406 and 420 is not sustainable. 406 and 420.
Yes.
As because Miller, as per annexure 1, I have entered into an agreement with the opposite party number 2.
Yes.
To sell my land. And he has paid 7,50,000 rupees as advance. As per the agreement, a particular time has been fixed. 17th of May 2021, he has to pay the balance amount and I have to register the land in questions. He never turned up. So I gave him a extension by giving another letter.
Yes.
And in that extension letter, I have specifically stated that if you will not comply with my request, then I will not refund back your advance amount. I waited for 1 year, sir. But he never turned up. So I have to sold that land.
You forfeited. You forfeited that amount.
Yes. I sold the land and never returned the money. For that purpose, this complaint.
Then you pay the money.
Milord.
How can you change the initial contract condition unilaterally by sending a letter? You tell me. Answer it.
Not unilaterally, Milord.
This is an agreement.
Yes.
In the agreement, there is no forfeiture clause. Show me forfeiture clause.
There is no forfeiture.
Then, by way of a letter, unilateral letter, can you change the condition of the contract?
The thing is like this, Milord.
Answer it. Yes or no?
Milord, I have given the land in question.
Different story. 7,50,000.
Yes,
admittedly, you are taken as an advance. Specific performance could not be done for reason XYZ. Your reading and willingness is expressed by you by sending a letter. In that letter, you said that yes, I will forfeit it if you don't come once again.
Yes, Milord.
And according to you, you have forfeited. I am not entitled to give that money. But that is not the law. Law is the initial contract condition.
He has already
cannot be altered unilaterally.
He has already filed a civil suit against me.
That's a different story. Then you have to face it now.
So I have a decision of the Hon'Ble Appeal Court on this line, Milord.
Give me if you are directly covered then. See, this is the fact. Show me the forfeiture clause. What happened to the specific performance suit? Has he filed?
It is in a hearing statement.
It's going on.
Going on.
Show me. Why don't you pay him in the money and finish it up? Specific performance everywhere you are running around.
Milord.
You have taken the money, you pay it. Try to be honest.
Milord.
Don't hide behind the
technicality. Actually, I sold the land because I want to go for abroad to have a.
Now what is the position? Will you pay or not?
I have to get the instruction.
What? You have taken the money, admittedly. Now you are shielding behind the technicality. This happened, that happened.
No, Milord, that is not the thing. The thing is.
That's the only thing, sir.
I can see that amount and whether he's in a position to rightly immediately pay it off.
Just forget about the past is past. 7,50,000 rupees pay a year. I'll close it. And you will get out of the specific performance also. Otherwise, section 20 of specific relief act, just see.
No, the case is there. Civil court is taken.
Section 20 is there.
Yes.
It is virtually I am passing the same order, section 20 order. And I'll quash the criminal case also. And in specific performance also, you will be out. Try to be honest, pay him.
No. I have to get instruction. But how?
If I'll dismiss, then all instruction will come.
Millard.
Yeah, your client is dishonest.
No, Millard. The thing is, I have not sold the land for my luxury, sir.
At the same time, 21, you have taken the money, you are enjoying it. You have to pay the interest.
Naturally,
you have to pay interest or not.
Naturally, sir. Naturally, if the suit will.
Forget the interest. You also face the loss, he also face loss.
But
and you sold your land. Not that you have not sold the land. But later on you sold the
I was supposed to sell because
whatever. Later on you sold the land, obviously it is a higher cost.
No, Millard. That is the whole
no.
pity.
Well, lands are not like that.
I have to sell the land below the agreement period.
But you had an intention to sell, sir. It's not that he forced you to sell.
Go abroad for my studies.
Then you should have sold it to him only. You sold the land, you've taken him the money, you don't want to pay. Either you pay or otherwise I'll dismiss. Decide yourself. Tomorrow, come tomorrow. No, nothing doing. I will not go into technical.
Time should
pay the money which you have taken. Because of your dishonesty, the courts are suffering. High Court, trial court, investigation, everybody will be doing your job. You will be dishonest.
No, Millard, the thing is,
come tomorrow, day after. Day after, come with the money, and I'll quash this proceeding. Your specific performance is taken care of. You will be happy.
It is not possible to arrange such a huge amount of.
What such a you have taken? You are going abroad and all this. What is this?
No, I have gone there for study purpose, sir.
Study purpose. You have to pay, sir. You have taken money.
No, he very much knows that I want the money to go for study.
Now you have gone to 21. You had gone. Now at 25. You might have come back or might be employed somewhere. You pay 7,50,000 rupees. Not a big money.
I have to.
I'll put it day after tomorrow.
No,
get it such.
Millard, at least 15 days time.
Monday. No. Monday.
It is a big amount, Millard.
What big amount, sir? 7,50,000.
I'm not such a big man that I can arrange those.
Okay, 10 days for 10 days. Get instruction. I don't think you have a case. Okay. Otherwise, I'll dismiss it. And this is a specific performance suit. Also, you get the status.
That is still hearing at the certified copy of the things.
At the cost of court time, you are enjoying. Yes. Next.
This copy shows that it is still there.
Shall I send you to the mediation and finish it up? There, he is waiting. Yes, Mr. Panda.
Concealing the facts. He was concealing the fact. Within that agreement period, I am approaching him with rest amount, but he denied to make the registration.
Oh, that is again you are fighting the specific performance suit. The fact of the matter is 7,50,000 rupees, and he has to pay today or tomorrow, either in that proceeding or this proceeding.
So
I'll send it to mediation.
No, sir.
And find out where if he doesn't have the money, take on installment and finish it up.
He sold the land around 70 lakhs. What I came to know.
All right, that is become a now history. Sir, think of the future and keep on fighting. What will you get? Nothing.
Yes, sir, actually. On the earlier occasion, he had said that
even if you get a degree under section 20 also, you have to get it executed. You know, execution is tougher than getting a degree. You know that. Better get wiser and take the money. I'll send it to mediation. Okay, I'll send it to mediation. The 15th item. 15th. Right. The petitioner is seeking quashing of the proceeding in ICC case number or FIR. ICC case number 143 of 2022, initiated by opposite party against the petitioner, which is pending in the court of STJM Deccan. The allegation against the petitioner is so. It appears from the record that the petitioner has entered into an agreement with the opposite party on 6th of April 2021 and has received 7,50,000 as an advance for selling of the land. For various reasons, the land could not be sale deed could not be executed in favor of the opposite party. There are claims and counterclaims regarding the non-cooperation by the petitioner as well as the opposite party against each other. There is a specific performance or suit also initiated by the opposite party against the petitioner, which is pending before the court, civil court. The fact of in a nutshell, the fact remains that the 7,50,000 rupees, which has been taken by the petitioner and on advance to sell the land, has not been returned. Rather, the same has been forfeited. I have carefully gone through the initial agreement dated 26th April 2021. There is no forfeiture clause in that agreement. Letter counsel for the petitioner submits that he had written a letter to the petitioner, to the opposite party, asking him to cooperate in the registration of the land in his favor. And in the said letter dated
This letter has been issued on 31st of May.
31st May, that is upper legal.
2021
And
against 2 million.
he has also made it clear that the opposite party will not cooperate with the petitioner. The advance amount of 7,50,000 rupees, which has been given to him, shall be forfeited. Accordingly, he has, since the opposite party did not cooperate with the petitioner for registration of the land, the advance amount given by him is forfeited. Making the aforementioned subject as the cause, the opposite party has filed the ICC. Regarding head to the facts of the present case, I am of the view that the parties should explore a possibility of settlement on mediation. Both the counsel appearing for the parties have also agreed to the proposition. And therefore, the matter is referred to the High Court Mediation Center. Coordinator, I am giving a date. Coordinator February, na? We are there, 3rd, 10th. The parties are directed to appear before the High Court Mediation Center on 10th of February at 4 p.m. 4 p.m. Thereafter, the coordinator shall fix subsequent date. Awaiting mediation report, release the matter on 21st. 21st interim to continue. You pay the money and finish it up.
Yes, I'll accept interim.
Yes.
All right.
Thank you. What did it say?
He is only annexed the affair manner. And he stated that there is some civil dispute is there. But prima facie on going through the affair manner, prima facie case is made out.
Huh?
In the affair manner, prima facie case is made out.
But the FIR is related in October 2024 only.
My lord, he has not submitted anything. The first time this case is called.
Okay. Non-appeals for the petitioner in the interest of justice. Release the matter. Friday. Friday. You get the status. What is
Friday? Next week, yes.
No, Friday. Chief opposite Friday. Friday, I'll dispose. Only I'm giving one opportunity. I'll dispose. Yes.
May I please also? Lord, here the petitioner is a financing company, my lord. He has filed this application to release the vehicle in his favor, which has been seized by the police.
Yes.
My lord, the vehicle, my vehicle bearing number is
Your vehicle is seized in which case?
My lord, your lordship may kindly see the FIR itself lost by the police, my lord, at page 23, your lordship.
Yes.
Categorically stated that the vehicle number is WB 14D 5961.
NDPS case, who all are the accused?
My lord, this vehicle is not my vehicle.
Hmm.
He has written categorically everywhere. He has explained that the vehicle number is WB 14D 5961.
Mhm.
But your lordship may see the seizure list. That page 30, my lord.
Yes.
61.
It is OD 03.
No, sir. Seta WB 14D.
WB, WB 14D 5961. In the FIR it is written. What
My
it
lord,
is, what
again, you will also may see the charge sheet which has been submitted by the police at
Yes.
page. I am coming to that page.
Yes.
Lord. Padala
The 55.
Whatever, 50?
5.
Yes.
My lord, page
What have you
55.
seized?
My lord, Ashok Leyland bearing registration number WB 11D. That is my vehicle, which has been
Yes,
seized by the
that is-
police. And it is lying since, my lord, 23/6/2023.
But in the charge sheet at page 55, it is 11.
My lord.
506, yes.
My lord, here in this case, my lord, notice is to go because he is the financer. And the original owner from.
No, in the FIR you have said some other vehicle. And his vehicle is now seized. Just see in the FIR what is the vehicle number.
FIR টা আছে না দিয়েছে এটা পরে
In the FIR vehicle number is WB
23
10D 5961.
14D.
charge sheet রে 11D.
I have to take instruction.
Huh? Okay, please.
And 13/6/2023, more than 1.5 year vehicle is lying there.
Sorted there. Mr. Naik, counsel for the petitioner, submits that he is the you are the owner of the vehicle.
I am the financer, my lord.
And the petitioner is the.
And that is the settled law, your lordship. The financer is the
vehicle number WB 11D 5961, which has been stated to which has been seized by the police in connection to the FIR number town Bolangir PS town case number 273 of 2023 for alleged commission of offences punishable under section 20B 2C and 29 of NDPS Act. He has pointed out from the FIR that in fact the vehicle number WB 14D 5961 was apprehended during the apprehended and the same is stated to be carrying contraband ganja. However, when the charge sheet, the subject vehicle is shown to have been seized. The petitioner is seeking the release of the vehicle number 14. What is that? WB 11D. 11D. 5961. Issue notice. Let's look at next. Go to week per day. It has to be released.
2 को भी जो है notice लगा because he has already paid substantial amount.
अच्छा 2 भी issue notice. Yes.
Item 12.
Let's sort that maybe.
Sort it. Yes.
Oblige.
Make it pleasure mercy. So the husband, opposite party is the wife. Wife is started a proceeding under section 45C.
Are you not well? Your voice is. There is little problem. Shall I put it tomorrow, day after?
Time.
Okay, next week, Monday, Tuesday.
But one thing, Lord, I request that since the proceeding is going on in Bhubaneswar, and he will pass order of warrant.
When is the date fixed there, trial court? Tomorrow. What is the stage?
Stage means the execution proceeding is going on. And the court demanded rupees 2 lakh some odd.
Maintenance thing, I can't say you have to pay in any.
Why? If your lordship will direct, I must pay it. But whenever this caste Samaj made a resolution with the members of caste people that they both diverse from each other.
The Samaj can't decide whether that diverse or not. You have to follow the due process.
The wife obliged the resolution.
Maybe. See, then all mutual divorce will be done by the society. There is a rule of law, 13B is there. You have to resort to 13B. On the basis of that, if divorce is granted, then it's understandable.
How my lord, collector allowed divorce pension?
Collector, I don't know how collector has assumed the power of court. I don't know.
She had applied for pension.
That is not the divorce. Divorce has to be done in accordance with law.
Not in a legal process, but Samaj has passed and both of
Samaj may do so many things. Then
by virtue of that, Samaj.
Then you do one thing. In this petition also filed before Samaj. Let the Samaj decide. Why have you come to the court then? You have taken divorce from the Samaj. Now when it comes to maintenance, you come to this court. Because you have to pay. Go to Samaj and decide it.
Why will I?
That's what your submission what to do.
No.
If you can get the divorce from the Samaj and you say you are relying upon that.
No, I am not the wife, I am the husband.
Oh, you are.
I am the husband.
You are disowning the divorce then?
So whenever the resolutions are there.
That's not the position. I will just issue notice if you say. I'll just examine, but there can't be a stay. Yes. Simply issue notice. Yes. Next. I'm simply issuing notice because it's a maintenance thing. I can't say. Yes, I'm issuing notice.
But one thing to that LCR be called. Now there is no other. But he will be arrested. Unnecessary. The collector has allowed pension. Your it is
12, item 12. Huh? Collector has allowed pension. What is pension here?
Divorce pension.
Where is that?
My lord, answer 14.
4.
My lord. Answer 14 collector's order.
Page?
On 3
Which page, sir?
Page 14, 16. 16. The order of the collector, Nagar. Page 14, 16.
16. One. Okay.
Answer 2 and 3.
Yes.
BPO has also given a report.
Yes.
That is, she had applied for divorce pension.
Show me that collector's order.
Answer 2 and 3.
Page
14, 15, 16.
This is Madhubabu pension.
Madhubabu, divorce, your lordship may see divorce pension.
Sir, why don't you understand? These are the government floated schemes. In that scheme, somebody is getting some pension. You want that should be counted towards the government. What are you talking about?
I'm reading the order of the video. So Sunita Nayak, Pita Lodu Nayak, Gramo Dihogan, Post Dihogan, Thana Dospala, Jila Noyagod, Khoirat Gosai, Bibako, Tanko Swanigo Namo Susan. Se କେବେ ଛାଡ଼ପତ୍ର ପାଇଥିଲେ ସେ ବିଷୟରେ ମାନ୍ୟବର ଅଦାଲତ କେବେ ରାୟ ଶୁଣାଇଥିଲେ ତାର ତଥ୍ୟ ଅତ୍ର ଅଦାଲତରେ ଉଲ୍ଲେଖ ନାହିଁ। ମଧୁବାବୁ ଡାଇଭର୍ସ ଭତ୍ତା ପାଇଁ 25/8/2020
No. He is getting some benefit of some scheme floated by the government. I am not interested in that. Simply issue notice. Yes. Next. He is getting 500 rupees from some Madhubabu pension, something. You want that should be counted towards the benefit. Maybe admitted. Yes.
36. Lord, case of 302, my lord. And the second successive bail application, my lord. Out of 31
custody since
custody, my lord, 14/12/2022, my lord. And out of 31 charge sheeted witness, 5 witnesses has been examined, my lord.
Yes.
I have supplied the deposition copy, my lord. And deposition PW3, my lord.
Yes.
PW3 and 5. categorically stated in their cross-examination that that is BW3, my lord, Raghu Chalan. Just a glance the cross-examination, my lord. My son Hari and his wife Gomati were leading a peaceful life, and I have never seen quarrel in between them, my lord. And same thing it was narrated by another witness, my lord, Vidya Chalan. He has also stated that. Hari,
What are the allegation against you? Let us.
my lord, I have killed my wife, my lord. Due to a quarrel, nothing, my lord, only a quarrel.
Who all are the eyewitnesses?
Eyewitnesses, my lord, they have not examined. In the affair, my lord, the one Bishnu Jani, Gar Bishnu Jani, evam Srikaro Jani dekhichandi. They have not examined.
Vishnu Srikaro.
Yes, my lord.
Vishnu Srikar.
My lord.
These two witnesses have seen. They are named witness. Anyway, the name of these two witnesses are written in the FIR itself.
My lord.
And they have been cited as a witness in charge sheet.
Charge sheet, yes, my lord.
Just check it out. Let them be examined right now.
Let them
be examined. Let them be.
Lord, fix a time, my lord.
I'll fix it. I don't know. Petitioner is also for petitioner also. Mr. Patil and counsel for the petitioner submits that 5 witnesses have already been examined in the present case. None of the witnesses were supported by the prosecution. Relying upon the evidence supported the all the 5 witnesses, the question for grant of bail petition. Mr. Janar, for the state has taken me to the contents of the FIR. In the FIR, 2 witnesses, namely, Vishnu,
yes,
Vishnu and Srikaro.
That is page 14, my lord. Vishnu Jani ebom Srikaro Jani dekhichandi.
Are the named eyewitnesses in this case. They have been cited as witnesses in the charge sheet. Therefore, I am not inclined to entertain the present petition at this stage. However, liberty is granted to the petitioner to renew the bail plea after the examination of Vishnu Jani and Srikar Jani. It is expected that the trial court should examine these 2 witnesses preferentially or all other witnesses, and the same exercise may be done within a period of 3 months.
Problem.
Yes.
Sorry, my lord. In my case, your lordship may be pleased to fix it short date, my lord.
I'm giving it. Yes. Next. 48 Shukruvar. Yes. 48. On APS. He's on police party number 2 officer. But no real appears. Even for petitioner, none appears today. In the interest of justice, Friday, I'm coming and now. Yes.
54.
Yes, madam.
Can I request my lord to take up this matter at the end of the board today?
See, these are the matters of 2016.
My lord,
And
I'm
it will
not
take
requesting
time.
for a time, my lord. Just at the end of the board at 3:30 or 4, my lord. I'm just requesting.
Are you really ready? Because somebody is asking adjournment. I told I'll not adjourn. And
My lord, my lord. My lord, Mr. Pal is the conducting counsel. He's here.
Memo of citation and death cert not filed.
You have not filed the chat also.
Memo of citation and death with memo. Sorry, my lord. File,
My lord, it is
Sorry,
fine.
we have of Mr. J.B. Pal.
He's on legs in another court.
Short. He has not even filed the written note of submission. Written note.
Complaint case arising out of a complaint case.
Written note of submission. He has
Filed, well, it is like written file.
Date chart and citation. He will not file a date chart and citation. Let him do so. Please the matter up to case.
My lord,
Yes.
entry model.
Entry.
My-
Yes.
56.
Lordship, this is for passing of the proceeding against the present petitioner, wherein he has been accused of the commission of an offense under section 13(2) read with 13(1)(d) of the Prevention of Corruption Act and section 120(b) of the Penal Code. Lordship,
What is the stage?
the stage is at the stage of framing of the charge.
Charge
Has not been framed. It is stayed by this honorable court.
Okay.
And Lordship, there is a covered decision regarding this point.
Achha.
May I kindly brief Lordship regarding the fact so that it will be very easy for appreciation of the covered decision.
You
Lordship,
have
the present petitioner.
Do you have any synopsis or anything else?
Note I
Not
have not prepared. Synopsis, then Lordship, to Lordship, may I kindly call it on Friday? I will write.
Friday?
Next week, any date after 10.
Please for Mr. Moon, land count for the petitioner, submits that he would be filing a relevant and the relied upon release the matter as the entry mode to continue. Yes.
So you will not applicable that different thought. And so far as he was saying that on that day, I was not being guilty. It's a different document. But documents show that you are in.
We'll see. Yes, that I will submit.
Okay. Yes, next.
There is also a note in the cause title in the list. Lordship may kindly see regarding this, that the counsel for the vigilance department has been ordered by this court to produce the authorization in respect of the petitioner by the commissioner.
No, that's what he got it. We'll see next time. Yes.
Lordship. 57, Lordship, this is a case under section 13(2) read with 13(1)(e) of the Prevention of Corruption Act. My grievance herein, charge sheet has not been submitted. I have challenged the FIR. My grievance is that you cannot invoke this section against two public servants jointly. The case has been invoked against both the husband and the wife who are public servants. The husband has retired. 1 year after retirement, this FIR has been lodged by including the properties which he had received towards his retirement dues. That has also been included, 74 lakhs and odd. And my grievance herein is that the law does not permit for institution of this case against two public servants jointly with the aid of section 34. That is what is has to satisfy.
Yes.
The case of petitioner, there is another passing of the FIR, and we are in investigation phase.
No, what he says is the DA case cannot be registered against two public servants
jointly.
One proceeding.
He is currently the 34. So we are in the process of investigation. Whether it will be 34 or 109 or 120, that is a matter to be decided when we file the charge sheet. Not at this stage. And he is admitted.
Hey, but there is no stay.
No stay, we are proceeding.
Then see, the FIR was registered.
20 December 20. Jari was said a case where not simple because we have to depend on the other leaves of the other organization. They deliberately accused with one to delay. And we are pressing at we are trying our level best to unearth the documents and records which are they are trying to hide. From on
You can file two separate FIR against both the.
The thing is that if the husband and wife they are residing in same place and jointly, that cannot be bar. That 34 is not.
Give me one decision. Give me one decision.
No.
I will concede my case. Which decision? Give me a reference to it.
This is 34.
34.
There you have a point. There you have a point. Still at the investigation stage, you never know.
କୁହନ୍ତୁ ଆଜ୍ଞା ରେଫରେନ୍ସ ଟା ଟିକେ କାଇଣ୍ଡଲି
ଏଇଟା
କୁହନ୍ତୁ ରେଫରେନ୍ସ ଟା କୁହନ୍ତୁ
CRLMP 985 of 2018.
କମଳା ମହାନ୍ତି.
Then got it. Para
And unfortunately, you only argued this matter.
my case it Kamala Bas that
last 2, 3, 4 lines. Besides from the admitted relationship.
in that case lordship in that case charge was framed for abatement. That's different. That's different.
Anyway,
Here we are
Mr.
in
Marana,
respect of 34.
you just tell me stage of investigation. Why you are getting late?
The stage of investigation.
No. I am asking you the stage. Yes. Where you have reached so far? Huh? You get it? Reach it up. Learned counsel for the vigilance, Mr. Marana, seeks to obtain the instructions regarding the status of investigation. Let him do so within a week. Reach the matter after a week. After a week. Okay.
Hearing time.
Lordship, pray for 1 week after.
On the request of petitioner, please the matter. Yes.
Lordship, a date can be fixed, Lord. In this case, my lord, I am for the informant. I pray for next week, my lord.
Informant.
Petition.
Opposite party, yeah?
Yes.
Opposite party. On the request of opposite party, please the matter.
Interim order continue.
Why you are allowing him to continue with the interim order? You should not ask time. Yes, anyway. You are. What can I do?
May I please this. Watching of proceeding. The offense on section 493 and other alleged offenses. The victim lady, the married lady, prior to the allegation made in the year 2023.
He is married there for 493.
He married in 2016. And the allegation she has made in the affair, while she was studying and staying at a hostel, there was a relationship with the petitioner. Thereafter, she married, left the husband, again developed the relationship with the petitioner. When the petitioner married, he filed the affair after taking divorce from the husband.
What to do now? You tell me. Evidence is there.
Yes. So for evidence, so for the allegation regarding 493 parties concerned promising marriage, that is not made out in face of the evidence as she stated and her father and mother stated. May I place the statement of her father, age 45 years.
Charge has been framed.
Charge, I have to take that instruction over what is the stage of the
charge has been framed, then at the charge stage you should argue all these things.
Yes. Have to take that instruction, what is the stage?
Yes, sir. Charge has been framed. Because whatever cognizance has been taken 2023. And now what is this stage? Cognizance of offense 493 is not made out according to you. All other offenses are made out.
So for the other allied incidents to the.
So then therefore you have to argue all this point at the stage of framing of charges. You say 493 is not made out.
To take that instruction, whether charge has been framed or not, I have to take that instruction.
Then counsel for the petitioner admits that he has no idea whether charge has been framed in the point case. Therefore, he seeks an adjournment to setting the state. Exactly the same. Leaves the matter for case. Yes.
62.
62 on behalf of Mr. Pahali, pray for next week. He is ill today.
I have objection, my lord. I am appealing for the informant, my lord. Your lordship, please to send this matter to mediation center, my lord, that has failed.
and the interim order is there, therefore, I pray, your lordship may dispose of the matter.
Yes.
Or a fixing a date, your lordship, as your lordship please, but short date may be fixed and further adjournment may not be granted.
493 was the same thing.
Usko
The
aaj
matter
kaise jaye?
mediation. The mediation has been unsuccessful. Therefore, the matter is set for hearing. At this stage, the counsel for the opposing party, counsel for the petitioner seeks an adjournment, to which the opposite party is objective. In the interest of the system, you may counsel. Yes.
63, may I please, your lordship? Challenging the order of cognizance, your lordship, in a case of in a complaint case, your lordship, against the petitioner, your lordship, and the
APF. Okay. Yes.
Your lordship, accepting the inquiry under section 202 CRPC, the cognizance has been taken, though the witnesses therein in the complaint case are different in the evidence taken under section 202 CRPC and contradictory to each other, your lordship. And it's a case, after third case and counter case to my case, wherein I have lodged the affair, the family members of the petitioners have lodged the affair under the 376 and POCSO Act, your lordship.
Yes.
And the person on whose name the affair was given, that he has been taken by the petitioner facing trial after his arrest under POCSO Act, your lordship.
Yes.
On that ground, your lordship, for quashing of the cognizance taken by the magistrate, your lordship, JMFC Narsingpur, in a complaint case 1cc 59 of 2021, this
So many complaint, if complaint and 202 statement.
Yes, my lord.
Case is made out. 354,506 only. Yes.
Yes. What, my lord? After my affair, my lord.
Maybe.
My affair under section 376 and POCSO Act was prior to that.
Merely because the FIR complaint is filed against you after you are FIR, doesn't mean that it will be.
No, I'm not saying. But this is the contradictory evidence has been given by the complainant.
I can't appreciate the evidence at this stage because it is a cognizance taking stage. Only cognizance has been taken.
Yes.
I can't appreciate evidences.
Liberty be given to file discharge petition during
file it
and object in the
is challenging the order dated petition is challenging the order dated 27/10/2022 passed by learned JMFC Narsingpur in ICC case number 59 of 2021. The accounts for the petitioner submits that the present petitioner is a counterblast to the FIR registered by him against
one of the member of the petitioner.
One of who is that?
Yes, my lord. Indramani Shahu, your lord.
Registered by petitioner number 1 against the opposite party. He has also pointed out to the contradictions in the evidence recorded in the preliminary statement made by the complainant opposite party in the ICC case as well as the statement under section 202 CRPC. I am not inclined to entertain this petition at this stage as at the stage of taking cognizance. The court is not required to appreciate the evidences placed on record. And in that view of the matter, the petitioner, and at this stage is seeking to withdraw the present petition, reserving the right to agitate the issue to the trial court to be appropriate state. With this liberty, the petitioner will dispose of. Yes, next.
64.
Sent for the mediation, it is 138 NI Act proceeding, my lord. Lordship may send for the mediation, my lord.
Service. Appear. Who is appearing? You want mediation?
Mediation, my lord.
What is check amount?
check amount is two checks, my lord, that 6 lakhs each, my lord. But it is I have already averred in my petition that either we have not received the notice, my lord, and for which I have not given any chance for giving the reply.
Those things.
So, your lordship may send to the mediation and
Mr. Who is appealing?
the amount has been received, my lord.
Item number 64. Project 19. Appear. The present case arising out of a complaint under section 128 where petitioner is accused. Notice was issued to opposite party number 2. He has challenged his proceeding. The entire
Yes, my lord.
and he has challenged the order dated 27/9/2022, whereby passed by Lieutenant JMFC 2, Bhubaneswar, whereby cognizance of in ICC case number 2876 of 2022, whereby the cognizance of offense under section 138 and has been taken into consideration. Notice was issued to opposite party number 2. Mr. Ajay Naik made appearance, but non-appears on his behalf today. This is Mr. Hon'Ble has responsible for the petition submits that the matter there is a chance of settlement in this matter. Hence, the matter may be referred to mediation center. Where is the district mediation center?
My lord.
District mediation center.
Well, here, my High Court mediation, maybe.
High Court mediation center.
Well, I is there, my lord. Stay further proceeding, my lord.
Nothing will happen because in the absence, service is complete. In the absence, 138 case, how can I?
No, well,
yes.
See, last statement था again. As mediation is settlement है जो till last statement था again. I had
65 yes. You can seek an adjournment. Yes.
Let's me observe this, my lord. In order.
Since the matter is referred to mediation, the parties are at liberty to seek an adjournment before the court. Yes.
My lord. Obliged.
May I please, your lordship?
Yes.
Well, I'm applicable to the respondent. Paper next week.
Sorry?
So I'm applicable to the respondent as a paper next week to appear.
Yes. Yes, Mr. Mishra, he is entered seeking time adjournment.
As your lordship, please, because your lordship was pleased to issue notice and granted also interim stay.
So entered appearance on behalf of opposite party number 2, opposite party, and seeks an adjournment to file response to the petition. Let him do so within a week. Leave the matter so interim to continue. Yes, sir.
Only he should provide an advance copy if at all he is filing a response.
Give advance copy. Yeah?
That's it.
Okay.
Obliged.
Order taken going on the challenge. As per the local complaints committee, the accused person exonerated. Basing upon that exonerated, they are seeking for quashment of the order taking cognizance of action.
Local, what is that?
As per the Visakha judgment, your lordship, harassment committee, local complaints committee exonerated the lordship. There is technically exonerated lordship.
Internal committee.
Yes, sir. 35 is the local committee order.
What are the allegations?
354A and 354B. A is 354, 354A is there.
Notice was issued. Yes, see.
Notice was earlier than 16/12/2024 the notice is issued. But I have not obtained the 164 statement. In their prejudice the charge sheet has been mentioned that there after the 164 statement recorded of the victim. That statement is not with me or not for the time being. 67.
Service complete. That's why service opposite party number 2 non-appears on her behalf. Release the matter even non-appears for the petitioner. In the service also entry mode to continue. Yes. Yes.
68, my lord. May I please your lordship? My lord, here in this case, the petitioner is challenging the cognizance order that is, my lord, that read 18/1/2019, passed by the SDGM Sundargarh, my lord. The case is that, my lord, initially FIR has been lodged offense under section 493, 417, 313.
Service complete.
Yes, already appear, my lord.
Yes.
I'm happy to the
You are
information.
happy? Yes.
294, 354, 351, 323, 506, 34, my lord.
Yes.
But when the charge sheet submitted, my lord, the offense under section 313 has been deleted.
313.
Yes, at
Yes.
page, your lordship can have a glance, annexure 3,
Mhm.
that is page 25, my lord, running page 25.
Yes.
So rest offenses, my lord, that is 493, 417.
Yes.
Yes.
Then what happened?
Accordingly, my lord, there is amicable settlement.
Information is uploaded, lordship.
Yes. What do you say?
Lordship, allegation is very severe in nature, lordship.
Like?
But 33, lordship, can glance for a moment, your lordship.
Charge sheet, come to charge sheet.
33, lordship, that is page 33, lordship.
Yes.
Lordship, what happened, the present petitioner, that is, initially has been 376 cases initially registered against him, and thereafter again, lordship, can glance 33, lordship.
Yes, I'm there.
Yes, your lordship. Thereafter, again the present informant 2 again lodged a complaint present petitioner for which was treated for under section 354B, 341, 294, 323, 506,
Yes, I'm
34.
submitting the
Yes,
same.
ମୁଁ ସେଇଟା କହିଦଉଛି. Now the present petitioner seeks for quashment of the said proceeding, lordship. By your setting that the matter has been amicably settled, that is affidavit flag B, your lordship.
Yes. Looking to the future perspective.
ମୁଁ ସେଇଟା ଖାଲି bring to notice of the court.
Well, but the informant, due to misunderstanding, is in first study is not interested to proceed with the case, your lordship. Informant is present in the lordship will permit them.
Yes. What is your name? Umesh.
Your lordship, present Umesh Kumar Sharma and there are other.
Umesh Kumar Sharma is the main accused,
All
my
of them
lord.
are there.
All of them.
Yes.
See the allegations. Just see the allegations.
Second so far, yes, your lordship, that is.
What kind of allegations? They were in relationship.
That-
There was settlement. She went up, and again she came.
That's it there, your lordship.
All these things are. Yes. Who is
Presented to the bank within the period of 6 months from the date which that drawn within present malice. Here in malice, that bank is clearly indicated that the check number 00043 is not presented. Neither penalty charges was reflected and nor any police complaint was filed by the bank minors.
Yes.
Here is the case minors. That check is not presented. Then
Not presented.
how is it possible the check was not presented? Then what is the how is it dishonor and how the cognizance taken without verify the proper document minors? That is my contention minors.
Come to page 17.
17.
17 para 5.
Yes, minors.
Read it. Para 6.
Malice.
Para 6. Read it.
Yes, yes, malice. I'm got it through the record malice. Para 17 malice.
You issued the check.
Malice.
Read it.
Para 17.
Para 6, page 17.
Yes, malice.
Yes.
That as per the commitment of the accused person failed to repay the aforesaid loan amount up to the complainant, and after several approach of the complainant 2 and 3 issue the delivered check number so and so, that is 28/2003.
Okay, you have issued next.
No,
para 8. Para 8. Come to para 8. Para 8.
That on the 3/3/2023 the complainant present the said check on our banker once ICICI Bank Limited, Civil Township Branch, Raulkela, collection of the check.
Yes. Next para.
That the check dishonored and returned due to payment stop by trial. And
Yes.
the bank authority returned the said check along with the return memo charged in 2023.
Yes. Next para. Next para.
That the complainant served the 3 separate demand notice. So and so on the 16/3/2023, on 17/3/2023
Yes.
of the
Demand notice.
Malaysia.
Next paragraph. Demand notice served on you.
Yes, ma'am. The demand notice
that 25/3/2023 and the advocate complaint received on.
This is what is the requirement for 130.
No, my lordship, that is not my contention, my lordship. That is not my contention.
Or all other contention you have to raise.
No, my
The
lordship.
defense can't be dealt with at this.
Then let him file objection on my.
I don't know what will he do.
Yes, my lordship. That
He may do, he may not do, I don't know.
My lordship, from the day one,
Check was issued by you, averment is there.
No, that is the stolen check, my lordship. The report is annexed with my.
And why have you not replied to the notice?
That, my lordship, that the notice, even my staff was received, not my.
It's required. That's the whole.
No, my lordship. That on the date of filing this case, my lordship, I am annexed the station day report, wherein numbers of checks were found in the position of the present complainant, my lordship.
Come to pay the same page, para 12. The accused number 2 sent the letter number so and so to the advocate complainant stating therein, I have received your letter on dated so and so. You know that the books of account lying with our parents, partner's husband, so and so, and who is looking after the company's matter. I discussed with him regarding your matter, and he told that what is this? Our account is going on, and it will take some time to finalize the account. That's what you are replying.
No, my lordship, that is after summon. After summon.
Whatever. That's
Then thereafter, my lordship, thereafter I'm filing a complaint, a police case, my lordship.
Anyway, it's all right. So all these
My lordship, when my lordship,
all these things are defense.
My lordship, definitely, my lordship.
Petitioner is
My lordship, that is judgment. This honorable court is there, my lordship. When legal verified, the debt is not liable. My lordship passed this.
That you have to. He has a right to prove it. If he
then
let him
file objection on that content.
I'm not exercising advisory.
How the drawer bank is stated that no such check is presented.
So this is the evidence you have to lead. And the same bank is dishonoring check.
I am a lady.
Notice was given to you.
My lordship, I am a lady. My lordship, that one day of the present in the accused dog is so many harass to me, my lordship.
Yes.
My lordship, that's why, my lordship, I am requested to you kindly let them file objection on that contention. If the check was presented, I am ready to file an affidavit, my lordship.
Can I force him to do something?
My lordship, this
Can
is
I force him to
case, my lordship. This is rare of the rest. The check was stolen and the FIR was already pending, my lordship. Station diary.
Something which is legally permissible.
Yes, my lordship. My lordship,
you got some RTI information. I'll force him to file reply to that. What is this?
Then, my lordship, I am filing affidavit, my lordship.
You do whatever you do.
That
is your problem. But you got some RTI information from the bank.
Yes, my lordship. Then let me grant time.
And he followed the procedure. And now these things are your defense.
I am wrote a letter to my bank where my account is there. They reply that no such check was presented. Then how they get the endorsement to maintain the 1cc case, my lordship? How they get the endorsement?
Why have you given reply that our account is going on? We will settle. It will take little time. Why have you given that reply to 130 notice?
No, my lordship, 130 notice. The 130 notice not required.
For everything, don't say no. It is averment.
My lordship, that is.
Have you given a reply to the 130 notice? Things are going on. Settlement will be done. It will take little time.
My lordship,
and today you are saying that you got some RTI information that our bank is saying that it was never deposited. What is this?
Then, my lordship, the ingredients of the NIT is not satisfied, my lordship. In this case.
Will you settle the dispute? 20% you pay, I'll send it to. This is the standard order.
No, my lordship.
Otherwise,
let him file objection.
I'll pass the order here.
My lordship, give it. That, my lordship, before passing the order, my lordship.
Next item.
My lordship, kindly have a glance. Before passing the order, my lordship, I'm requesting you, my lordship. I'm praying before.
What do you want?
Ready, my lordship.
What do you want? What do you want to show? Tell me.
My lordship, then this document, I'm officially obtained through RTI.
I'm not conducting trial. Why don't you understand? You file an affidavit on that basis and decide the case today.
There is a decision, my lordship. Even if honorable apex decision is there, my lordship. Honorable apex decision is there. Having with me, my lordship.
I don't know whether you are trying to convince me or I am trying to convince.
No, my lordship. My lordship always right, but
we should change the place.
No,
I am trying to convince you that you don't have a case.
I have the decision of honorable apex court.
Try to understand all these things which you are going to show. Those things are after trial. If he is not able to prove that it is legally recoverable debt, then you are entitled to an acquittal. That's the law.
My lordship, if possible, my lordship, I am a lady, my lordship, I am respectful lady, my lordship. The accusation against me, one day ଯଦି ଆଜ୍ଞା ମୁଁ ଗଲି କୋର୍ଟ କୁ ବି ପଛରେ ପୂର୍ବ ଆଜ୍ଞା ମୁଁ ଦୋଷ କରିଛି କରିନି କିନ୍ତୁ ଲୋକ ସମାଜ ଆଗରେ ମୁଁ ଦୋଷୀ ହେଇଯିବି ଆଜ୍ଞା କି ମୁଁ ଗୋଟେ ଚୋର
The best part is you have a very good
That's why Manasi, I am applying
persuasive
for my
capacity.
lordship.
You are still trying.
That's why I am approached with my lordship.
I'll pass the order.
No, my lordship, kindly have a glance of my lordship. My lordship.
Simply put it next week. Huh? You get some judgment. Okay. He is
Yes,
pursuing.
Manasi.
He is trying hard. Let him get some judgment. Okay.
Yes,
Direct judgment if you have.
Yes, my lordship.
Next time, my lord, brother, what happened here, my lord? Last time, my lord, submitted that, my lord, he is in my office, my lord, for
Yes,
some
my
time, my
lord.
lord, and he is feeling nervous. Today, my lord, I am here, he is feeling nervous. Next time, my lord, I will not come, my lord. Your lord, please take care.
You know, I am tempted to tell you a joke. One young lawyer like him, he was arguing in a court. When the court said, no, I will not give the relief, he said that, my lord, this is my first case. The court gave the relief. Next, his senior was appearing in another case. He also argued, the court said, no, you don't have a case. Then he also said that this is my first case. The court said that, what are you talking? You have been appearing. No, today this is first case. Exactly the same thing he is doing.
And next time I will not come, my lord. My lord and friend, my other friend will do it, my lord. He'll feel comfortable. So that, my lord, he can make submission to your lord.
Okay, you should be happy that
Yes,
your training
he is
shows
trying his
that
level best, my lord. So I am happy, my lord. He is by.
from your office is doing very well.
Yes.
Okay.
My lord. The case to quash on the ground of settlement. So, charge under section 6. The POCSO Act. POCSO Act, my lord. My lord, matter has been settled, but my lord knows the position of law. So, my lord, may directed to further examination of the victim as the informant. I have also enclosed the copy of the order that
You
was
have to
passed.
do an application there, sir, 311.
My lord, yes. That flag P, my lord. At flag P. P.
Rejected.
PW 1 and 2.
Rejected.
That has been rejected.
Have you challenged this order?
No, your lordship.
No. On the last occasion, my lord,
amendment.
sir told
Challenge this order. Without challenging the order, how can I set aside? If that order is not challenged, how can I set aside?
my lord, because it's an application on section 482.
No, 482 doesn't mean that you have not challenged some order and I'll quash it.
This is the
You must
position.
challenge that order.
Order of cognizance under challenge, your lordship.
You have challenged the cognizance order.
Yes.
Now you move, trial is going on.
Yes.
You moved a 311 application, which is turned down. That order has to be challenged. How can I? In a petition under challenging cognizance order, how can I set aside an order pass under 311? You challenge that order. I'm giving that liberty.
Yes, my lord. That liberty we can.
Learned counsel for the petitioner seeks to withdraw the present petition to resort to the remedy available to him under law on the changing circumstances. He submits that he had moved an application under section 311 CRPC for recalling PW1 and 2. Who is PW1?
My lord, informant, a victim. PW1 is the victim and PW2 is the informant.
PW2 is informant. The said application has been turned down by the trial court on 6/2/2024. The petition is disposed of as withdrawn with liberty and back. Yes.
My lord.
Yes.
71.
Please, your lordship.
Yes.
Case is, lordship, petitioner, his close friend, while traveling by a Honda City car, lordship, all of a sudden a cow came in front of the road, for which they made accident. His close friend died. That is at page 50, lordship, the statement.
Yes. 279, 337, 338, and 304. Yes.
Page 50, lordship.
50?
50. Everything will be clear, lordship. ମୁଁ ଅକ୍ଷୟ କୁମାର ଦାସ ଆଜି ଅମୁକ ତାରିଖରେ ବୟାନ ଦେଉଛି। ମୁଁ ଗତ 22/12/16 ତାରିଖରେ ପ୍ରାୟ ସନ୍ଧ୍ୟା 9:20 ମୁଁ ମୋ ଘର ସୀମାପୁର ଯାଉଥିଲି। ଠିକ ସମ ହସ୍ପିଟାଲ ଠାରୁ କିଛି ଦୂରରେ ଆମ ଗ୍ରାମ ପାଖରେ ଦେଖିଲି ଗୋଟେ କାର ଯାଉଛି। ରାସ୍ତା ଉପରକୁ ହଠାତ୍ ଗୋଟେ ଗାଈ ଆସିଯିବାରୁ ଡ୍ରାଇଭର ଗାଡିକୁ କଣ୍ଟ୍ରୋଲ କରି ନପାରି ରାସ୍ତା ରୋଡ ଡିଭାଇଡରେ ପିଟି ଦେଲା। उक्त कारटी उक्त रास्ता ऊपर दुई तीन गोटा है पलटिया एक्सीडेंट हेबार देखि सेटा लोक जमा हे गेले मु मध्ये से गाड़ी पाखु जाई देखिली जे पागो गोटे होंडा सेठी कार अछि जार नंबर है सेही गाड़ी रे 4 जण लोक थिले ड्राइवर पाख आगो सीट रे जणे पछ सीट रे 2 जण थिले लोक माने के सेमान को गाड़ी रे बाल करले गाड़ी रे ड्राइवर सीट आ मो क्लोज फ्रेंड आ मु आमे 2 जण इंजर्ड हेलु आ तापर
Who is the informant in this case?
informant se got a relation he was not in the spot lordship now pursuant to that I pursue the remedy under the MSCA now MSCA court lordship page 38 MSCA court page 38 awarded 38,59,000 in favor of the my friend this is now lordship it is a case of 2016 this man is pursuing a student lordship.
In the MSCA case, the father of the parents of the deceased has the complainant, the claimant, your lordship. May notice issued to the claimants whether that amount will be received by them or not.
MSCT.
No, I am not. By judgment is there.
Judgment.
You have not implemented them. You should
Not
you
they have
treat
not
them.
party the
Mr. Naik, counsel for the petitioner, seeks leave of this court to implead the informant and injured in the present case. Let him do so within a week. Issue notice to the newly impleaded respondent 2 and 3. Mr. Mahanti accept notice for date.
केवल कॉपी देवी कहीं से जो घरे रोहुले आम पड़िशा रे पुओ चली गला परे से आ नाहंती बॉम्बे की दिल्ली सेठी असुविधा नले एठी भी आसी न थांत सेठी मोर कंप्रोमाइज हे जाई सांत
That's what I implead them. That is I am aiming at that. See, they got the compensation. They may not be interested. They may not be interested to prosecute you now. So I am issuing notice. Is there? Implead them.
पुलिस की डायरेक्शन हेले केवल मिल परिबो नल मु पाइबो
Notice. You first of all you have to implead within 2 days. 2 days. Notice notice to respondent number 2 and 3. Newly added respondent number 3 shall also be served through the IIC. Which was this thing? IIC. From the Kandagiri. Kandagiri. Yeah. IIC. Okay. Notice through IIC. Yes.
address nahi to kichhi
But implead immediately. Yes.
Extra copy.
Extra copy.
Item number 72, my lord. Impleading by impleading
Implead first implead. Yes.
Item number 72, my lord. Your lordship, previously lordship directed the learned counsel for the state to collect the status report before collect the details.
Yes.
How many cases are
not yet received? Lordship let it come.
One more.
Your lordship, in the meantime, how many cases pending against the present?
Yes, you get it.
Not, I
The order dated 17/1/2020.
Of the OP number 3 and a copy also not received.
Shown to entered appearance for opposite party number 2.
3, my lord? 3 in CRLMC number.
OP3.
3 and Mr. Sahu to supply the copy of the petition. Mr. Mohanty, counsel for the state, submits that he has not received any instruction as per the order dated 17/1/2025 on the matter of the week. Yes.
Your lordship, connecting matters, 2 matters are there, my lord. CRLMC number 192 and 220. Notice may kindly issue, your lordship.
Give the numbers. Please,
Numbers already tagged in the previous matter.
Tagged.
But notice is required, your lordship. Notice to the OP3.
Notice in the connected matters. Yes, next. 73.
73, that matter. PMLA and schedule
My
of
lord,
things.
in item number 72, may I pray?
Mr. Hon'Ble has some
72 is over.
My lord, may I pray for protection in 3 matters?
1 minute. Let us know how many cases are there first. Yes.
Lord counsel for the ED has some difficulties because he is on his legs. So requested me to urgent this matter to tomorrow.
Part hurt election matter is going on. So Mr.
Yes. Tomorrow, no problem.
Tomorrow may not be possible.
Because 6th, date has been fixed to 6th.
Keep it on sixth. only. Fifth, huh? Fifth, okay. Fifth, okay, fifth.
Obliged.
Yes.
74th.
Yes.
If a lordship permits, says that matter, where my learned friends appears for the opposite for the petition of lords, one of the RI lords. In fact, if lordship turn to page 13 of lordship brief lords, the charge sheet copy, there are 5 accused persons. 5 accused persons. The first 2 are the tahsildars, and the 3, 4, 5 are the RIs. The one-line allegations against them, lords. In fact, they allowed 197 OLR cases and converting all the agricultural lands to homestead lands, lords, by accepting lower amount of premium amount, that is 3 lakhs, lords, and in contravention of government notification of 5/10/2024. What I suggest, lord, my learned friend appears in one case, lord. Another 5 persons are there. Well, I have come through another 2 cases. I'll just furnish the other 2 cases.
The other cases were, do you have the particulars? Have they filed any petition?
One case I know, Lord. I'll find out the case number. I'll also, from the computer system, Lord, I'll verify if other cases there that can be tagged.
Okay. Okay.
And this is a case, my Lord. In fact, my learned friend should be released because of 2 reasons, my Lords. One is that other 2 cases to be attached to this. Lord. Same process can be disposed of, Lord. And tomorrow is a very auspicious day for my friend. He will be celebrating his anniversary tomorrow.
He refused to celebrate.
As quickly as possible.
So he said that he adjourn it, but not tomorrow. That's what.
No, I'm ready. My friend can argue this case. I'm ready to argue this.
No, he says that other accused persons are also.
It will context to page 13, lords.
He just you just check it up. Any connected matters are there?
Page 13 of
the matter and fix it for a day when I can hear it.
But on Monday, 10th or 11th.
Monday.
Except tomorrow.
Next week. Wow, we'll leave the next week. Then 17 or 18? 18. 18. Okay, 18. Yes.
But if an application will be filed because charge date, I don't know.
When the date? Just tell me if that date is there. You just verify and tell me so that I can pass the order. If it's not there, not there. Yes. Next.
75.
Yes. Senior advocate.
Lordship permits development is the family of some
He has only requested me to keep it on
apart from that, Lords,
family for the learned counsel, senior counsel appealing for the petitioner, hence urgent.
Apart from that, another points involved in that particular case. Once a delinquent is
directed me to submit the judgments on the issue.
Once a delinquent is let off in a DP, his automatic ipso facto will be released from their tribes.
Other matters are there.
Okay, we'll see.
Interim order is there.
Interim.
File an adjournment petition.
Same arrangement continues. Yes.
Adjournment.
Adjournment.
And next week or
2 weeks. Good week for them.
Sorry,
good week for next week will be.
Retirement full
Yes.
Only 1 week after I would say.
Yes.
On 18th.
18, 19 days. Yes. Where is Miss Marana?
Lordship, she is saying that.
My lord, permit me on behalf of the system of the discharge for today. Times I am last document director of the court first step against respondent number 15.
76.
Yeah.
I mean, they were in the hospitals, but they were fixed. For my endeavor, that has been mistake. Forget me.
I'm challenging the order passed by the. Are you ready now? I'll just go to the next point. Wait. Weekly, na? Next. Let's go through. Let us see. Blue matter can be disposed of. Yes, sir. Under section 30 of the Insurance Compensation Act. The main ground of challenge that the admitted case of the applicant is that due to the injury, accidental injury sustained by him, he had suffered temporary disability. The Act of the WC Act, Employees Compensation Act, section 41C. What is the award? Award is minus 14 lakh. Award is minus. Award is 22 lakhs 17,271. And mere minutes as per section 41C. For the sake of assessment of loss of earning capacity, total permanent disability depending on some kindly have a glance. Section 41C. Let us understand the facts first. Let us understand the facts. The fact of the case that the applicant claimed that he was driving the one like a private car of the restaurant number female. And while he was going from Chandigarh to Bangalore, he parked the car. And while he was crossing the road, he taken in the restaurant, he was dashed by an own car and had sustained head injury. There were 2 police cases have been registered. And in fact, the SCB initial statement paper also documented that he had sustained alleged injury due to any road traffic accident. Later on, one discharge certificate was filed. In that certificate, it was revealed that he had sustained the injury due to accident. Permanently disabled? No, not permanent. Temporary disability. This is the certificate we have filed. They have admitted case. What is the percentage of disability? 50% temporary disability has been assessed by the medical board. That has been admitted by the PWR. Right from the who attended the evidence on behalf of the injured. The same has been admitted by the deputy physician PWP. They have also filed the disability certificate, which reveals that the same works. With the disability certificate, the extent is also there. That is the medical. Temporary disability value for 3 years. The requirement is the disability must be total and permanent for the sake of assessment of loss of earning capacity as per the Employees Compensation Act for the sake of assessment of compensation. The disability is temporary and loss of earning capacity permanent. This is the mandate of the Employees Compensation Act. According to you, then it is not a permanent disability, no compensation being paid. Can be over. The next one. In case of temporary disability, this is taken into consideration for assessment of the compensation. That has not been found. And in a regular method, as of the disability, don't calculate it. So many calculations now. So many calculations done. Yes. Calculation that I have not done. So many calculations. According to you. I have not done on the basis of temporary disability. What is the difference amount? The difference no, 14 lakhs just come to page that I am over. I think the 14 lakhs. Well-reasoned one. Well-reasoned award. Well-reasoned award. Let's see. Therefore, the amount of compensation in case of comes to 60% of your wages into that formula is applied.
Because this is a temporary disability.
Into 80%, 14 lakh 82,000.
Because this formula is not applicable in case of a temporary disability. They have proved that case that the applicant have suffered temporary disability. That assessment, the process of assessment is wrong.
You give me your formula then, and let us see.
Then you will also call this matter next week.
That is the only argument you have.
No, argument. This is the statutory mandate.
Hey, on the basis of this formula, which is adopted, this is the right formula. And even Pronacity recognize this kind of.
No, that principle of pronacity is applicable.
I know that, but the overall principle has to be taken into.
No, this is a separate government.
I understand, I know that, but what is the calculation according to you? You tell me.
Here, the other 2 points are there also. If your lordship is asking
If it is
about the
if
calculation,
it is a huge difference, then I can interfere. Otherwise, you see, it's ultimately the company.
let me file one calculation chart on the basis of temporary disability. Monthly wages. I will.
You must be having that because your whole entire case is that.
No, not the calculation chart. I am not having it with me at present. That is the thing. Your lordship call this matter.
Let it be there in the list.
I am appearing for the.
Have you calculated according to him?
This case is not around a single word temporary. He is explaining the court that temporary means not sustainable.
No, 50% is temporary. That's what he says.
Can we see section 2G of the Workman Compensation Act?
Workman compensation.
He is referring a full dictionary, which means temporary means not permanent.
I know.
That is the statutory provision.
It was around this particular word temporary. Section 2G of the Workman Compensation Act defines 2 types of disability.
Yes.
That is one temporary disability and other is the permanent disability. Temporary disability means the disability which debars the person from the work you are doing at that point of time.
Yes.
Here in this case, because the driver and he sustained paralysis of one side. That's why the disability certificate was issued, declaring him 50% disabled.
Come to page 16 of the judgment.
Yes, page 16.
In order to prove the physical disability.
Yes.
Page 16.
I have filed the disability certificate and also.
You read the let us see the finding. In order to prove the disability, physical disability, loss of earning capacity of the applicant. That paragraph. No. Page 16. 1/6. Judgment.
Judgment to page 16, page 7.
You have filed page 16.
That is.
Okay, issue number 3. Issue number 3.
Under issue number 3.
Under issue number 3.
Yes, sir. In order to prove physical disability and loss of earning capacity, the applicant has produced original certificate, disability certificate issued by medical authority that Odisha on examination of the certificate. It is assertion that the applicant is permanently disabled and cannot do his professional work anymore. Even stated that applicant has a case of locomotor disability.
Diagnosis of his
This is paralysis, right side. He has 50% figure in percentage temporary disability in relation to right leg, vein, shoulder, right arm, neck, elbow, front finger, head, right arm, right leg, elbow, spine, knee, leg, elbow, guideline. All this is injuries are there. He 50% paralyzed, my lord. He is saying that there is a temporary disability.
You have to, the applicant himself have.
No, it is a permanent disability. One part of the body is temporary disability.
No,
that is the appreciation.
No, that is the certificate. That is the reason I have suffered.
How will you find wrong this finding?
Because he is temporary disability. I have supplied the copy of the
finding is on examination of the certificate. It is ascertained that the applicant is permanently disabled
That is the wrong finding.
and cannot do his professional work anymore.
That is the wrong finding about
And
permanent disability.
If it and he has narrates what kind of
And your lordship,
disability certificate.
the disability certificate is temporary disability.
I don't think there is any scope of interpretation.
I am referring the certificate you are predicting.
No, again the same thing. What it says, just see, it says that the right side leg, in relation to right side leg, the 50% disability. Overall disability is permanent.
And this
that's the finding.
And this certificate
only I am reading.
This certificate is valid till 25th August 2025. And now your lordship, I will take your lordship to the admission of
And
the
tribunal, the court has really appreciated this. And he said that disability is 100%, no problem. But the one side of leg, that right side of the leg is 50% disabled. And for these are the
50%. And my lord, they are treating physician, my lord. They are treating physician.
How much you will give? You tell me. Come to the point.
Here, my lord, your lordship.
Settle the dispute. Otherwise, I will dismiss it.
Oh.
Try to be, he is disabled. He can't work anywhere. 14 lakh rupees is nothing.
It's a huge money.
Huge money for the company like you.
Saying that
you are after all
little money. Here, my lord, how the calculation was done. Calculation, my lord, the employer said that he was paying rupees 10,000.
The reality is these insurance companies, private insurance company, while taking premium, they'll take. While giving, they are very relaxed.
The insurance company, my lord, they are taking premium not forcibly. Rather, it
no, forcibly.
That the full
they generally take forcibly. The type of pressure they create, that is more than
they will create pressure. If somebody wants that,
come to the point. You want to check.
Now, your lordship, kindly have a glance. LCR is there, PW2, evidence of PW2. The doctor examined by the applicant.
Yes.
That is cross-examination. ଟିକେ ମୁଁ କହିସାରେ
hard copy ଅଛି. Okay. Oh, what is it? No? At this project. Yes.
May we request one thing, my lord, can you see section 2G of the workman compensation? In that case, it will be.
Yeah, I am also referring to statutory mandate. Without total permanent disability, no assessment can be done.
Workman compensation. Workman compensation. Books is also not there.
Section 2.
Yes.
Partial disablement means where the disablement is a
section you already
section
2. Yes.
Partial disablement means where the disablement is a temporary nature, particular word temporary. Such disablement as reduces the earning capacity of an employee in an employment which he was engaged at the time of accident, resulting in the disablement. And where the disablement is a permanent nature, such disablement as reduces his earning capacity in every employment which he was capable of undertaking at that time, provided that every injury specified in part 2 of Schedule 1 shall be deemed to result in permanent partial disablement. So, the meaning of temporary disablement means disability to perform the work of a driver which we were performing at the time of accident. Permanent disability means the disablement to do all other work, including that.
Yes.
So, this is the meaning. He is referring to dictionary meaning that temporary means curable.
Now your lordship,
section 4, what he was referring also.
Section, your lordship, kindly have a glance. Section 41C. 41C.
Okay. 416. Yes, sir.
My lord.
Yeah.
But subclause 1. In case of an injury specified in part 2 of schedule 1, such percentage of compensation which should have been payable in the case of permanent total disablement as is specified therein as being the percentage of total permanent. I am giving emphasis to the total permanent. In the case of permanent total disablement as is specified therein as being the percentage of loss of earning capacity caused by the injury. Part 2. In the case of an injury not specified in the, this admitted in non-scheduled injury. In the case of an injury not specified in the schedule 1, such percentage of compensation payable in the case of permanent total disablement as is proportionate to the loss of earning capacity as assessed by the qualified medical practitioner, permanently caused by the injury, permanently. That word has been given, that permanent.
Yes.
Here means for temporary disability, subsection D has prescribed how the compensation should be assessed.
D, yes.
Where temporary disablement, whether total or partial, resulted from injury, a half monthly payment of the sum equivalent to 25% of monthly wages of the employee to be paid in accordance with the provision of subsection 2.
Yes.
As for subsection 2, that has to be assessed in case of temporary disability.
Yes.
Here, members, since the applicant has suffered temporary disability, the learned commissioner should have referred to this 4(1)D subsection for assessment of the compensation. That has not been done. Though in the judgment reflected, it is temporary disability. PW2.
Temporary disability is part of the body. That's what the finding is. That's the certificate you are relying.
Then the assessment here, that principle is part of the body, is applicable to the motor vehicle cases, where that Rajkumar Ajaykumar judgment is there. That even if the disability has been assessed 50%, the tribunal has to assess the functional disability. Here the question of functional disability is not there. Here the loss of earning capacity. In case of scheduled injury, that loss of earning capacity has been prescribed in
that is the finding. It says that he is not capable of working.
No, that is finding is that finding is erroneous. That is the reason because their treating physician PW2 has admitted that the petition applicant had suffered temporary disability.
He was a driver, no?
Yes, here the driver.
Here,
paralysis. My lord, can
how
how a paralysis right? He should not granted a
PW2 cross-examination.
PW2?
PW2 cross-examination.
Yes. PW.
Another doctor.
Okay. PW2.
Shall I read it?
I'm there, sir.
On 25/12/2022, the applicant approached for the purpose issuance of certificate with regard to LOC. I have gone through the disability certificate issued in respect of the applicant by medical board, that which reveals the applicant was suffering from a temporary disability of 50%. I am not an orthopedic specialist. I am a neurologist. I am not a neurologist. I had not issued used any apparatus for assessing disability. I have not mentioned in respect of which ailment I have issued the disability. I am not competent to issue disability certificate. Thereafter, assess the LOC to the extent of 80%.
In the read it, he also says that I have not mentioned the percentage of restriction movement, and I have not also assessed the disability as per the schedule in the injury mentioned in the EC Act. He has not assessed that also. Medical board of the competent authority has issued the disability certificate. I have not advised the applicant to approach the medical board of disability. I do not have direct knowledge with regard to the occupation of the applicant and so on.
Not assessing the.
He is not assessed in as per the Act. That's
He
what I was
issued a disability certificate, he had not assessed. That is in violation of section 41B minus. Explanation that the treating physician has to refer to the schedule given in the employee's compensation.
Yes.
That has been not done.
PW.
PW2.
Section 4, 2C you have, no? Yes. Any other point? Well, yes. Any other point you have? Any other point you want to ask?
No, here and the next question, well as assuming, then also you are assuming, kindly have a glance, the finding of the learned commissioner.
Yes.
Here, my lord, the owner of the offending vehicle, owner of the car, admitted that he was paying the monthly wages of rupees 10,000 per month. The learned commissioner, now you are assuming, internal page 6 of the judgment, interim judgment.
Yes.
Here, my lord, third paragraph, issue number 3, third paragraph.
Yes.
So far as wages is concerned, the applicant in his claim application has stated that at the time of accident, he was getting 15,000 per month from the OP1 as his wages. And to corroborate the same in his oral evidence. On the other hand, the employer opposite party number 1 in his written statement as well as in evidence also admitted that he was paying rupees 10,000 per month to the applicant driver towards his wages. Hence, I relied upon the evidence of the OPW1, who is the paymaster of the applicant. And in absence of any specific contrary evidence, I hold the wages at 15,000. Relied on the evidence of OPW1, who said that he was paying rupees 10,000, but accepted 15,000. Paymaster.
5,000 per month.
Where
does it say? Where does it say?
It is in the evidence, my lord.
No, where is that? Show me his evidence. If he says 10,000, how can you presume that 15,000 and take 9,000 as 60%?
I was paying rupees 10,000 per month,
Where?
including allowance. This is it.
No, where is that? PW?
PW1. PW1.
Okay. Let us see. Okay. Yes.
First paragraph, my lord.
PW1. Yes.
I am owner of the car bearing number certain sir and one Vinod Pal was working as a driver in the said vehicle.
No, PW1.
Yes, ma'am.
PW1 is the
PW1. Owner, opposite party witness number 1, PW1.
okay.
That is Rakesh Kumar Naik.
Rakesh Naik.
First paragraph, ma'am.
1 minute.
24/3/2021 at about 10 a.m. my driver Vinod Pal was driving
1 minute.
to take
1 minute, sir. Let me reach there first. I don't have a copy. I have to from LCR. I have to find out.
Mark, please.
Where?
Mark, please.
From LCR.
LCR is there.
LCR is there.
Mark.
Yes.
Highlighted that person. He was paying 10,000 as salary, excluding fooding allowance.
Yes. No, what is the fooding amount?
100 rupees per day, but
You can't read everything into the evidence. See, he only says 10,000 I am paying per month, excluding fooding allowance.
Fooding allowance, the driver PW1 has stated that I was getting 100 rupees per day for fooding allowance. Fooding allowance is also in paid in cash and it can
That's
be
there,
added.
but 5,000 where? How has he ended? 5,000.
Because the PW1 widow.
On the basis of 10,000, if you calculate how much it comes, 6,000, 9,000, 6,000 it will be.
Another dispute is there about the age. That
Oh, you just now forget. I'm with you insofar as the income is concerned. You
This
tell me,
also makes a difference.
calculate because total compensation is 22 lakh something.
Then allow me 2 days time, I will file a note.
File a written
Note of parliament to
File a
calculate.
written note. See, the total compensation comes to 22 lakh 17,271.
Right.
Okay. And if the salary is taken to be 10,000, then 60% of that will be 6,000, isn't it? On that basis, you have to calculate. Now he has taken it to be 15,000, and he has taken 9,000 as the calculation.
Right. Allow me 3 days time at least. I will file.
File written note. Written note. Written note within 2 days.
2 days.
No, because see, it will be piled up, then it will go somewhere else.
No, you're fix a date.
No, I will not fix up the date. You will fix a date then after 1 week.
No, after
Better.
fix a date on
Come with
that.
part heard, partly the appeal is partly heard, and the parties to file their written note of submission, release the matter for further. Yes. So before I forget, huh? Yes.
The evidence of the doctor.
Yes.
Can you see the doctor has stated?
Oh, that day I yes.
Interim order to continue.
Yes. Yes, it's next. Yes. What is the
How much amount that's 16 lakhs.
total award?
16 lakh 94,000.
54. 15 lakhs. Yes, 15 lakhs 94,000. Yes. Yes. Yes, sir. You tell me.
We have been challenging the judgment of issue case number 2023 of Hon'Ble Labour Commission. The case is being filed by the complainant that the deceased was the driver of one Vikas Pradhan, and when he was engaged for the delivery of the gas cylinder to the village, and Vikas Pradhan was the owner of the gas distributors. And during the course of employment, he received the one phone call from one other persons. Then his driver was killed him.
So
then suddenly he shifted to the government hospital.
It can be heard. It can be heard. I'll keep it, and least only it will retain its position. Yes.
Kindly make a call for the LCR because the
LCR is not called for.
The case has been which is the party. Respondent number 5. He is not a stranger. One case is filed against the stranger. He is not a party. So kindly for the LCR.
Yes.
Today I will serve the commission.
Today appellant undertakes to serve the copy of the appeal paper book and call for TCR, leasing attention. Call it once you call it 80.
May I please, Your Lordship?
Yes. Yes, madam.
Your Lordship, in the last occasion, Lordship has directed respondent number 2, C, H, and I to enter into appearance. But again, in the noting, it is clearly seen that they have not yet entered into
Appearance.
the last occasion was given.
C, H, and I.
Notice has not been sufficient probably. I am appealing for respondent number 1.
Not sufficient.
In the noting, there is noted that tracking report is with the record.
Service 2C, H and I.
Seems sufficient.
All are sufficient.
Your Lordship may keep it for final hearing any
Okay.
date next week.
The notice on the respondent to C, H and I is sufficient as per the postal remark. But nobody has appeared, entered appearance on their behalf in the interest of justice, is the matter.
Your Lordship, accepted.
My lords,
Obliged.
my lords, am I audible? I'm appearing through VC, my lords. My lords, I'm appearing for the petitioner in item 81. My lords, as per the noting, it shows that the notice is not sufficient. But however, we have been contacted by respondent number 2's counsel and we have served the copy.
My lord, I am appearing for opinion number 3, respondent number 3. Today I have received the notice. I pray 2 weeks time for filing the workload number.
Just check it up. Two. 3 she is appearing. 2. You take fresh step for 2.
My lords, my lords, Advocate Adiraj Mahanti has already contacted us. He stated that he is appearing for respondent number 2 and he will be filing the Wakalat Nama. And we have also served the e-copy on him also, on respondent number 2.
Let him file the Wakalat. Yes.
My lord, the interim order to continue in the
Yes.
If here on the appellant, I have filed the substance on the session particular the issue of the appeal is within time. In the entire amount 20 lakhs amount I have deposited, but there is no delay before the commissioner Barampur Ganja. So that's no issue. Notice
Notice has not been issued.
No, it's a press matter.
Okay, simple.
Within there is no delay.
Okay, issue notice to opposite party. Let me know. Where is that order of commission?
Annexure 1 is the order.
Persons to the impugn order, dated 30th November 2024. The petitioner has already deposited the amount, entire amount.
Entire amount I have deposited. Receipt I have receipt I have attached.
Amount of complete changes. So before
the commissioner here.
Before the commissioner.
Before the commissioner. Commissioner for company session.
Okay, issue notice. Call for the trial. Yes.
So I have filed.
Then
yes,
you have already deposited a full recovery.
Lordship, regarding item number 84. Lordship, regarding item number 84, I have a small prayer. I have filed a IA for additional evidence. The IA is not there in the list. IA 1628 for 2024. 1628 for 2024.
That he has filed an IA being one
IA number 1628 of 2024,
which is not listed today. The same may be listed.
I see.
It's listed.
Pardon to make a mention. Item is 7 minor.
Then let it be there.
Item 87 minor. Kindly take on the supplementary list any day.
It will.
Item 77 minor.
Yes. Yes. Get ready. I'll hear it. I'll pick up 1-2 meters every day. I'll try to pick up 1-2 meters. Get ready. If you there, you come by 3:30 or so, so that
item 77.
NCR barcode is there. Get it prepared. Get it prepared then.
My lord, 87.
Let it be there. Prepare and take the pen drive.
My lord, 87 is ready for the on the.
I am retaining it in the list.
Item 77.
My lord, item 68. Today we have already repeated and check
it. It should be honored.
Yes, obviously, my lord. Within 5 days. Or we can make RTGS, my lord.
And we later deposit tomorrow. And honor, after getting it honor teller, then only I'll upload the. Otherwise, I'll not upload. No.
It should be honored to the court order, my lord, not that.
I don't know. You, how can you undertake for you? Let it be honored.
Well.
She will tell the Miss Marana. Then only.
Item 77, my lord.
And you don't understand the trauma one might have undergone. 1 lakh rupees is nothing. Right? And madam, you deposit, huh? Deposit and tell Miss Sarita Maran. Take it.
Okay. The check should be original check is
Original check she will take. She will take. Photocopy we are retaining. Yes. Original. Receipt करेंगे नहीं क्या?
Receipt already है. हाँ, already received, my lord.
Court receipt बोले give the original to her. Yes. One mention something.
Item 77, my lord.
Yes.
Past. Actually, there's an imprimatur operating against me for that very reason. I'm mentioning this matter to be heard. The counsel for the applicant is also ready for.
I'm retaining it in the list itself. Huh? I'm not saying anything. Let it be. It is weekly list. It will be there. I will accommodate you. Don't worry. Okay.
Item number 83, also the petitioner is an old man not getting any pension, vigilance case, a lot of criminal appeal of 2009. So it might be there in the weekly list.
It is there. It is there. I'm not disturbing. Get ready. I'll pick up one, two matters.
Submit.